The meeting is being recorded.
Okay, let's see here. Let's give this a moment so I can see the attendee list is growing as I'm looking at it. And good morning, everybody, to our meeting. If anyone who is attending the meeting today would like to make public comment at this time, if you could please raise your virtual hand so that we can see who would like to speak, that would be very helpful.
Justice Fitzgerald, I'm sorry, but can we start with roll call?
Yes, go ahead and do that.
Okay. Sean? Brynolson?
Present.
Felmet? Fleischman?
Here.
Hamilton? Judge Harper? Hartston?
Here.
Kirchmeier?
Here.
McRae?
Here.
Olvera?
Here.
Justice Fitzgerald?
Here.
Robinson? Ms. Robinson actually sent an email that she'll be joining a few minutes late. Judge Rubin?
And he will be joining at about 10:30.
Shining?
Here.
Sarouche?
Here.
Spira?
Here.
Torres Zambris? Judge Wiley?
Oh, is Judge Wiley disappearing? Oh, here we go. Judge, you're on mute, Monica.
You're muted.
Yes, I'm here. Thank you. I think I had to change position where I was for better connectivity.
And Judge Yu?
Here, thanks, Louisa.
Okay, and as of right now, I only see one hand up on the attendee list. Okay, so if we could please have Pete Bennett speak. 3 minutes.
Mr. Bennett, your mic has been enabled and you should be able to speak.
Little bit of a lag on my end. Can you hear me yet?
Yes.
Okay, thank you. My name is Pete Bennett. I have started engaging public comment with the State Bar, and I'm going to share with you a couple of very tragic scenarios where my losses are in the millions. I lost a case, excuse me, Bennett versus southernpacific.com. That's Bennett vs southernpacific.com. In 1989, my losses were $2 million in the Contra Costa County Court with Judge Peter Spinetta. Everybody in the room knew my witness was dead but me. Floyd Brown Jr., graduate of College Park High School around 1985, vanished. No record. He was shot dead in Concord, California, and they covered it up. There's no death record. There's no reference to me. I was never notified, nothing. I think my attorney, Richard of Bennett and Johnson, stole my money. I can't prove anything because over the last 25, 30 years, people have been trying to kill me. Everything from my F-250 blowing up on a freeway with me inside. My girlfriend, everybody knows the Amber Alert story with Alicia Driscoll and her beautiful little daughter. That was my girlfriend. Many of you in Southern California know the story of the family of 5 in Springville, Utah, found dead, and the father blamed for killing his children. That's my nephew. I have 7 murder-suicides. My attorney, Don Moats, disbarred. Offices were set on fire and torched, destroyed. My records destroyed. My attorney, Sage Sahapi, representing me, which became Bennett versus Collins. He was beaten up in Walnut Creek. You can find up at least a reference. I go to courtrooms and Judge, what's his name, Barry Good. I had modification and a move away prevention order for my sons. They said there wasn't enough time to hear my motion.
You have 30 seconds remaining.
Thank you. I got one more minute. And then top it off, Attorney Mark Angelucci. That would have been my attorney. He was gunned down and killed. The system is broken. The judges that I've encountered, one of them, Judge Joel Gulab, took my license for 16 years with $20,000 in fines for just 2 traffic
I'm
tickets.
sorry, your time is up.
All right, thank you, Mr. Bennett. Is there anyone else in the attendee list who wishes to speak? I do not see any hands. I will keep an eye on that throughout the day and invite public comment at various times. All right, thank you, Mr. Bennett, for your comments. And now to the task at hand, which is not a small one. And I thank Leah and Louisa and everyone who's been working quite a bit over the last few weeks and months to move us forward to today. I believe that everyone has had an ample opportunity to look at the executive summary, including the correction that was made. And I'm going to turn it over to Leah to get us started.
All right. So what I propose to do today, or plan to do, is to just walk the group through the resolutions. Louisa, if you can put those up on the screen, and we'll take them in the order that they are presented in the memo. For the first one, which is the Rule 5.4, I'm going to ask Greg to walk through the revisions that were made in the rule, to reflect the working group's decision on March the 4th.
Sure. Okay. And just as a preface, again, the purpose of these rules is really to capture the policy decisions, policy recommendations of the working group. I think the revisions that we have made to Rule 5.4 do that, it's particularly in reference to the recent resolution on co-ownership of law firms and fee sharing within a law firm. So walking through these changes. So in paragraph A, we added the, after share legal fees, we added the terms for the licensed paraprofessional services. That was intended to emphasize that licensed paraprofessionals can practice in the same firm of lawyers and share fees for the paraprofessional services with the lawyers or other paraprofessionals in the firm, as well as other individuals or entities permitted under the limited exceptions under A 1 through 6. It does not, however, permit the paraprofessional to share legal fees for the lawyer's services, except to the extent permitted under the lawyer version of Rule 5.4A3 as a firm employee. In some discussion with Amos, he had suggested adding a comment to Rule 5.4 that makes clear that fees generated by a law firm through the work of lawyers cannot be shared with paraprofessionals. And I think that's an advisable thing to include, or at least as a recommendation to the Rules Commission that will convene later to actually do the hard work of coming up with a final set of recommended rules. And also to emphasize that paraprofessionals can be employees of a law firm without raising any issues under these rules. So we will note that as a potential comment. If we can go down to paragraph B, changes here are intended to underscore that the licensed paraprofessional can only form a law partnership or other organization authorized to practice law if they do so with other paraprofessionals. And so that's the change here. Slide up. The change here was to remove the term who is not a lawyer or. So a lawyer has been removed. So it's clear that they cannot form a firm with a lawyer. C, there was no changes to C needed because it doesn't implicate the policy decision about co-ownership of law firms. Moving to D, this closely patterns the prohibitions for lawyers, but with 2 main exceptions. what is now subparagraph 1 makes clear that a paraprofessional cannot practice with or in the form of a professional corporation or other organization authorized to practice law for a profit if a licensed paraprofessional and a lawyer own any interest in it. And there's the exception for fiduciary representatives, which is the same exception for lawyers under the lawyer rule for a limited period of time. If someone either is deceased and is part of a settlement of their estate, for instance, during the administration of that estate. 2, we retain 2, and the reason for that is even in situations in which paraprofessionals combine together to own their own firm and no lawyer is involved in that firm, they cannot combine with somebody who is not a licensee of the state bar. And this is the close cousin to the D1 paragraph for the lawyer rule. And the only other change is to add paragraph 5, making it clear that if a licensed paraprofessional is practicing in a professional corporation or other organization authorized to practice law for profit, that licensed paraprofessional cannot have any supervisory authority over any lawyer or have the right or authority to direct or control the lawyer's independent professional judgment. The remaining paragraph, E and F, I think E was actually taken out in June. F is no longer necessary because those concepts are now incorporated into D. And it was also envisioned to provide additional restrictions if there was co-ownership permitted. Amos also had a comment, I think, when we were going through these revisions. Well, why don't we have these kind of prohibitions for somebody who's working in a nonprofit organization? That is actually already covered both under the lawyer rule and here under this rule, under what is now paragraph F. It makes clear that a paraprofessional cannot practice with or in the form of a nonprofit legal aid, mutual benefit, or advocacy group if the nonprofit organization allows a third person to interfere with their professional judgment or their client relationship, or allows them to aid and abet in the violation of law. And that is really the purpose of this rule, really at bottom, is to protect the independent professional judgment of the paraprofessional. So that is those are the changes that we made. I did review this with Steve Fleischman and Amos, so I don't know if either of you have any comments you'd like to make.
I'll briefly say that I agree that this revision captures the policy proposal that has been made, removes the ability of paraprofessionals and lawyers to co-own law firms. It's not as clear as would be best, but this is just how the professional rules work. And in operation, it's actually the lawyer rule 5.4 that prohibits lawyers from sharing fees from work with paraprofessionals or non-attorneys. So that's why I recommended some comments to make that clear, because it's actually the separate attorney rule 5.4 that has the restriction. But this is consistent with the policy proposals, and I support it.
Anything from you, Stephen?
Yeah, I just wanted to say I agree with Amos. I did have some concerns about this rule. Greg was kind enough to take 10 minutes to talk to me about it yesterday, and I'm in favor of it. Greg, in A3, should profit sharing be one word or two words?
It's one word, I believe. I'll double check, but I believe in the lawyer version of the rule, it's one word.
That's fine.
Yeah.
While he's looking that up, I just want to say again what an amazing job Greg has done.
Yes.
On this project.
Thank you, Stephen. You're right. It is actually hyphenated. I don't know how we lost the hyphen there, but
I didn't even consider hyphen as an option, but okay.
Okay, so shall we amend that? Right, so that it says profit sharing, which actually makes sense that it would be hyphenated. Okay. And I also want to give my thanks to Greg. This is obviously not exactly an easy task. Any other comments before the proposal gets put up? Yeah, I mean, we obviously talked about this at length at our last meeting. This reflects what the group wished to do. So Leah, or Louisa, do we have the proposed language?
The resolution is here.
Okay, so at the very top, it's simply, and I'll read it. It says resolve that the CPPWG adopts the proposed language for Rule 5.4 as reflected in Attachment A. And am I correct? Attachment A will be exactly what is beneath this and what we just looked at?
Yes.
To eliminate the ability of paraprofessionals to own a law firm with attorneys. Is there anyone, and you're gonna have to speak up because with everything on screen, I'm not able to see everyone and can't see people who've raised their hands. So if anyone would like to so move or propose a different resolution, if you
I
could.
move we adopt the resolution.
All right, so that is Fleischman. And then is there a second?
I second Judge Wiley.
All right, thank you, Monica. So Judge Wiley for the second. Is there any further discussion? And I'm going to scroll through everyone's windows as well to make sure that I'm not missing him. Ira.
Yeah, I'd like to state, it's mainly for members of the public who might be listening or watching. My reasons for being against this, very briefly, is that I think that it's not that I think, the paraprofessionals are subject to ethics rules that are the same as the lawyers, virtually the same. For all intents and purposes, as they say, they're the same. And therefore, I think that they should be able to be in firms with lawyers, co-owned firms with lawyers. That's it.
All right, thank you, Ira. All right, I don't see any other hands and I don't hear anyone else piping up. So Louisa, would you like to take the vote?
Bashan, Brynolfson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Hartston,
Yes.
Kirchmeier,
Yes.
McCray,
Yes.
Olvera,
Yes.
Robinson.
There's a Nicole Robinson in the attendees. I had emailed Lisa, but I know she was busy. I'm wondering if that's the Nicole Robinson who needs to be promoted.
The very good point, Erica. Thank you.
Sure.
Now I'm going to look at everyone in the attendee list now that you've said that. Super.
She should be joining shortly.
Great.
Thank you, Juju.
Yeah, of course.
Hi, Nicole.
I've been trying to figure it out.
Well, you can thank, Judge Yu for having the eagle eye and going through the attendee list and seeing your name on there.
Okay, all right. Yes.
Robinson. Yes.
Yes.
Judge Rubin,
And Judge Rubin, I don't believe is with us quite yet.
Shining,
Yes.
Sarouche,
Yes.
Spyro,
No.
Torres Ambriz, Judge Wiley,
Yes.
Okay, so that
Judge
obvious.
oh, sorry,
So
Sorry.
I didn't get to vote yet. Sorry, go ahead, Louisa.
Judge Yu,
Yes, thanks, Lisa. And Ms. Robinson, I can imagine it was like being in a terrible dream, right? Like you're trying to speak, but no one can hear you. So I'm sorry, I should have spoken up earlier. I sent an email because I didn't want to interrupt the discussion. But thanks.
11 ayes and 1 no, the motion carries.
All right, thank you very much. Leah, what's up next? And you're muted.
Right, if you could put the next resolution up, Louisa. So this next resolution, I made a slight modification to it just to try to have it read better. So I'm putting that proposed clarified resolution up on the screen. This is not in your memo, and I did not send this out in advance. I want to acknowledge that. So the resolution proposed in the agenda item is listed first, and this is essentially that the collateral criminal practice area would be amended to prohibit paraprofessionals from representing non-citizens due to the potentially negative consequences for that population. In the proposed amended resolution, the language has just been expanded somewhat, and I highlighted those changes in yellow.
And let me just jump in for 1 second before I invite comment on this. I'd also in particular like to invite comment on the second half of it. In most of the resolutions historically, and those that have been at least tentatively prepared for today, we have not put in a because, for the following reasons. This one could read potentially just that the working group recommend amending the practice area to prohibit paraprofessionals from representing non-citizens, period. I would invite the group to have a discussion about whether they want to do it that way, whether you want to include some explanatory language, which of course is because we want people to have the appropriate and best representation and are concerned about the complexities of non-citizens appearing in criminal courts and all of the potential immigration consequences, which we don't foresee being within the ambit of education or what would be appropriate for paraprofessionals to be handling. So kind of with that backdrop, if anyone wants to, first of all, well, we can start with the resolution or we can start with the discussion. Is there someone who would like to move a resolution? And if so, which one or something different?
I'm sorry, you may not be able to see my hand.
No, I can't. And I'm going to say it again. When these things are up, I cannot see people's hands absent constant scrolling. So just speak up.
Okay, thank you. So Sharon Bashan and I were the subgroup that worked on this. And I think that given how people who may not be citizens or who may not be documented feel about the legal system, if we just said the first, which is that, paraprofessionals cannot represent non-citizens, it may be interpreted in a way that we don't intend, and it may seem like we're just saying you're a non-citizen, you don't get access. And so I think it is better to include that, due to the complex and potentially negative immigration consequences for non-citizens appearing in criminal court, I think that makes it more transparent and clear that why we're doing this, because years later, people may not be going to the legislative or whatever history. And also if one is kind of a litigant, you're not going to know to go to the history. So I wouldn't want it to feel like a chilling or bar to people who are not documented.
And so Judge Yu, would you like to move the second one that's on the screen, changing the word to for non-citizens?
Yes, I'd be happy to make that motion. Thank you for making the change.
Okay, so let's make that correction so that it reads for, and let's please remove the highlighting at this point from that second resolution. And could we please remove where it says resolution as posted to the agenda? I would just like to have just the actual resolution that's being discussed on the screen. Is there someone who would like to second this resolution? And feel free to speak up.
I do, Fleischman.
All right, thank you, Stephen. Okay, so having a resolution on deck for us to discuss, I believe I saw Amos's hand.
Yes, this might be directed at you, Judge Yu, because you were on the subcommittee that proposed this, and Sharon Bashan, it does not appear, is on the call, but it always raises a red flag to me, making non-citizens ineligible for legal services. Typically, that would be something I would vote against. And I don't know that immigration consequences of criminal issues is so complex that it can't be handled through training and advice from paraprofessionals. So I'm interested, since it's your motion and you are on the working group, to hear your thoughts on it. Is this really too complicated to advise people that there are potential consequences, immigration consequences?
Initially, I think we didn't think it was because we didn't have this carve out. But based on the comments from the public, it may be. As you may expect, we're dealing with it every day in court, and we don't ask people, but we know that, especially in the assignment I'm in now, which is including diversion and treatment and allowing people to have things dismissed, and then even record clearance, even arrest relief granted. I know that there are different types of collateral consequences for people. And sometimes we think that our case is the only thing. Then we find out that they actually have other cases and there's other collateral consequences. So
and also to jump in, judges, just for a second, because you're speaking under, about the state court, but there's also potentially federal court, federal immigration issues related to state court proceedings.
Yes, and I was just about to say, so I don't know if we have enough knowledge to talk about this and then whatever happens at ICE or on the federal level. So either I think we should have someone retained or someone with that expertise to advise us, or I'm guided by the public comments. And I'm sorry, Amos, to not be able to answer very well because I don't know and I wouldn't hazard a guess. And I think Julia has her hand up.
She does. Yeah, Julia.
Yeah, I was just going to also comment that for the same reason we couldn't include a practice area for federal law because we don't have jurisdiction to tell federal law what they're going to do. I would say the same should hold true for immigration law because it does, especially if you're a non-citizen, but you are a legal permanent resident, the crimes can cause you to be deported, even if you're here legally. So I just recommend that we stay out of this because it is federal law. And just like we decided with bankruptcy, we couldn't carve that out because it was federal law. So that's all I wanted to say.
Erica, you're muted.
Thank you so much, Justice Petro. So I'm wondering if I should ask to amend my motion to include the language due to the complex and potentially negative federal and state immigration consequences. So it's really clear that it is not that we're targeting people who are non-citizens, but that this is sort of includes a federal issue, because I think Julia's point resonated with me.
And Stephen, would you be okay with that as the second?
Yes, absolutely.
All right, so if we could please amend that to insert after the word negative, federal. Do you want federal or state or federal and state?
I would say federal and state.
Okay, so that's been amended and approved by both the first and second. And I see Brady's hand.
I was just, maybe I'm missing something. What is a state immigration consequence?
I don't really know, but if there are any and we don't, I don't know. I'm not really sure what the dovetail is. I don't know that area of law well enough.
I mean, as I read it, I see your point, adding federal to make clear, hey, this is why we're doing it because it's this other area of law, but I'm not aware.
So what I'm thinking of is
state
more
immigration law.
I'm sorry, Brady. I'm aware of certain counties that have policies that if somebody is identified as being on an ICE hold or something, then there's some policies that counties have. I'm not sure if states have similar things. I haven't looked into it, but I definitely know that there are federal and county impacts on people who are not documented. I mean, I'm happy to take the word "and state" out it if that feels more proper.
Ira?
Yeah, two main concerns. One is that there's a federal law and maybe a state one against discrimination on the basis of citizenship or lack of it in public accommodations and other things. And I don't know, I wanted to research this. I haven't, I just did a little bit. I don't know if this resolution would violate that, would be illegal. Number two, it sure sounds bad. It sounds terrible. And And number three, and now it sounds terrible to the public. I imagine this appearing in a headline tomorrow or something. Number three, even though it's true that, well, that there's complications for non-citizens appearing in criminal courts or any courts, the fact remains that non-citizens can seek, for instance, what do you call it? 1203.4, the penal code, what do you call that? Expungement or the like. And having paraprofessionals help them with that, I don't see how that makes any difference in the consequences of the availability of expungement. No, I don't see how that makes any difference to the problem of non-citizens appearing in court or not appearing in court. I don't see what exactly, I've read the materials. I don't see what the problem here is. If a paraprofessional gets a.
So I'm sorry to interrupt, Ira. I keep hearing noise from someone, and so if someone is clattering around and doesn't have their video on mute, please put it on mute. And Ira, go ahead.
If a paraprofessional gets an expungement or the like, something similar, for a non-citizen, how can that harm the non-citizen? Maybe it can, but I don't understand. And if the paraprofessional tries and fails to get the expungement, we all know that that's not res judicata. They can try again. So I don't see any reason for this. I see a possible illegality, and I see a terrible picture for this for our group.
I know other people have their hands up, Justice Petru, but because it's a staff recommendation, I just pulled up a public comment that we received from Neighborhood Legal Services that I think was impactful to me. So it said, if an old conviction makes a non-citizen deportable, filing an expungement petition on that old conviction could inadvertently bring the non-citizen to the attention of ICE. Any declaration filed with an expungement petition is public record, and any admission of guilt in the expungement deliberation could potentially be held against the individual in immigration proceedings. So essentially saying sometimes you may not want to pursue the expungement at all if doing so will bring you potentially to the attention of ICE. That was impactful to me, in reading through the public comment. So just wanted to share that.
All right, thank you. And Amos, your hand is up. Did you have further comment?
Yes, just briefly, I want to explain why I'm going to vote no on this. I do agree with Neighborhood Legal Services comment. There certainly are potential negative collateral consequences, but I think excluding services for non-citizens is not the right answer. I think there should just be training for paraprofessionals on those potential immigration consequences, and the needed service should be provided to citizens and non-citizens alike.
And Erica, I believe your hand is up.
Yes, thank you. I was wondering if paralegals did a lot of work in immigration, and so maybe we're worried about something that we don't need to, because if they have this ability to be specialized in immigration, perhaps this is something that is a training issue, as Amos said. And then also in our county, we have a public defender named Beth Chance, who knows all the legal consequences in the public defender's office that does expungement petitions. And also her specialty is immigration. So everyone goes to her and asks her, I mean, if we need it, we could ask for additional outside information.
Well, I don't know that we're going to have any more meetings after today. So, I mean, I think the question, this will be obviously a live issue, regardless of what gets voted on today. There's obviously a lot of process ahead, and I very much doubt this will be the last time that anyone is discussing this issue. That being said, we do need to understand if there's a resolution on the table. So with your comments, Judge Yu, do you still so move?
Well, actually, I was going to ask Amos if there was anything that he felt could be added to the motion that would address concerns, or Ira.
I mean, I could support an alternate motion that collateral criminal should include specifically training regarding, potential immigration consequences for non-citizens. But I don't support this motion because I do think, I think a few years ago, it was new and different that there are collateral consequences, immigration consequences in criminal court, but that I think everyone practicing both in criminal law and immigration law know that now. And so I believe this is a training issue.
Okay, and Ira, I presume your answer is the same. You don't have a change to this, although you might support something different.
I had in mind exactly what Amos was expressing.
Okay, so if we get to that, I will ask one of you to pipe up with a motion. Elizabeth.
I'm wondering if this is a moot issue because immigration consultants are the only ones who can really help people with immigration matters if they're, bonded and registered with the Secretary of State under Business and Professions Code, Section 22440.
Right. I understand that, Elizabeth, and you're correct about that. But I think here the concern is they're not helping the person with their immigration matter, but they need to be aware of potential consequences in order to appropriately assist with the scope of collateral criminal matters.
Okay, and the other thing is that, for example, there's also resources out there like the Immigrant Legal Resource Center that, sends out resources regarding, what are crimes involving moral turpitude that will put people in immigration proceedings. So there's resources out there, and I would vote no on this because, again, when you're excluding people who have the choice to make decisions of who they want representing them, I think I agree with Ira's statements that it is kind of discriminatory. But if this were to be passed, I would make a suggestion of, so when you say non-citizens, if I'm a paraprofessional reading this, I would say, well, I can't help non-citizens, but I can help, like Julia said, green card holders, right? It's kind of misleading when you say non-citizens. It means, oh, well, I can help people who are green card holders. So maybe just clarify something along those lines.
Thank you, Elizabeth. Julia?
Yeah, I mean, I think it's important to say non-citizens because, green card holders are non-citizens also. I just think the reason for doing this is to protect the immigrant consumer, not to cause them hardship. And if there is a way we can explain that, because I'll say in my ABA approved paralegal program, we have one class on immigration. It is an elective. It is not like all paralegals have some big training in immigration law to be aware of these pitfalls. And at times I have practiced in this area, and there are a lot of different complicated things that must be considered to not get that client in worse trouble than they're already in. And I think it's a benevolent thing to say they should not be taking this on, and this should be left up to someone who's really trained in that area.
Okay, thank you. Elizabeth, did you have something else to say?
Yeah, just the last point would be just that I think a lot of whether it's an LDA or an immigration consultant or maybe in the future a paraprofessional, when cases like this do come up, I think that they will be smart enough to refer cases like these red flag cases to attorneys. So let's not forget that that's still also an option.
All right, thank you. And Erica, just 1 second. I just want to make sure there isn't someone else who I'm missing. Okay, go ahead.
So if I have my Roberts rules correct, a substitute motion would be voted on first. And I'm thinking I'm going to vote no on my motion. So I'm wondering if someone would like to make a substitute motion. And I do have a short meeting at 11 that I have to get to, but I would be back. So just letting people know.
So you are correct, Judge Yu, on Robert's rules, but I also think you can withdraw your motion.
Yeah, you can withdraw it.
Okay.
And I will go ahead. Oh, go ahead.
But I hear that like Julie and others have support for it. So I didn't want to deny people an opportunity to vote if they wanted to on that motion.
Fair enough. Let me make an alternate motion. I don't know if somebody can type this on the screen, but I'll just go off of the start here.
speak slowly so that Louisa has the opportunity to type it.
Yes. Further resolved that the CPPWG recommends amending the collateral criminal practice area to, so I'll save that, specifically require paraprofessionals to be trained on.
Hold on, slow down. Go ahead.
Potential immigration consequences.
And I think we missed a word. After trained, it should be on, trained on potential immigration consequences, plural.
Correct, for non-citizens.
Period.
Yes.
And paraprofessionals with an S.
Thank you.
Okay, and let's put the rest of that language further. Don't delete it, just move it down in case we need it. Okay, so this resolution, this proposed substitute resolution reads, further resolve that the CPPWG recommends amending the collateral criminal practice area to specifically require paraprofessionals to be trained on potential immigration consequences for non-citizens. Amos, is that correct?
Yes, thank you.
I second the motion.
And Judge Yu seconds the motion, and Stephen Fleischman has his hand up.
Amos, assuming this passes, do we need to modify the table on page 20 of today's agenda to reflect this change under collateral criminal training?
I think we could. I don't know if it's necessary since it's a separate resolution. I think it could be added. I defer to Leah on that.
Yeah, well, we can figure that out after. Julia?
If this is the motion before us, I just wanted to comment to express why I will be voting against this. I think that it will not be easy designing a curriculum for paraprofessionals to be trained on all the ins and outs of immigration consequences as a result of criminal conduct. And I just don't think it's reasonable to include at this point in the curriculum. So that's why I will be voting against it.
Thank you, Julia. Carolyn?
Yeah, I just want to say I really hear what Ira and Amos are saying, and I think that's very admirable. And I think that is something that, and I could say that there's lots of things I agree about what they're saying, but I think Julia's right. And also I would go with what the legal services people are talking about. It's very, very complicated and the risks are very high, especially this late in our program to go back and revise everything that would be implicated. That's all.
Stephen, did you have something further, or is your hand up from before?
It's from before. I apologize.
No worries. Okay, I don't see Fariba.
So I'm a little confused here. So Julia, are you saying that this area should be completely excluded or just included without any requirement for education?
I'm saying I don't think that paraprofessionals will be adequately prepared to deal with the types of matters that will cause their immigration status to be altered potentially. I do have some personal relationships with people who have been deported as a result of criminal activity, and they had to get a pardon from the governor to be allowed back into California.
Okay.
And I'm just saying the risk to me is too high, and we should not be putting our toe in those waters. I just think and because of our reasoning about why we weren't going to advocate for bankruptcy to be part of this program, federal practice, I do not think should be a part of this practice.
All right, thank you.
So does that mean that you would want the first resolution or to exclude this practice area altogether?
No, I would have been in favor of the one we were working on that.
So I think,
Okay.
Right, so I think the answer is yes, because I think Reba was asking you, were you in favor of the prior resolution that posted prohibiting paraprofessionals from representing non-citizens?
Yes.
Yes, okay. Ira,
What Julia just said made me think of something which is this, trained on potential immigration consequences for non-citizens might be a little too broad. How about trained on potential immigration consequences of collateral criminal proceedings for non-citizens? Or actually that new words would go.
but this is within the, I mean, I'll turn to the people who made the motion, but my understanding is this resolution is specific to the collateral criminal practice area.
Well, it is, but it says that the paraprofessionals should be trained on potential immigration consequences. Well, consequences of what is one thing.
Could it just say, I'm sorry, because I want to vote on it and I have to leave soon. Could it just say potential collateral immigration consequences?
Well, I don't know. Of what? All right, what I'd propose is that potential immigration consequences of non-citizens, I can't word it right, but I think that consequences of what? Consequences of the collateral criminal proceedings, because otherwise I think.
Well, it could just say that. It could say consequences of the, please type this in. And then
to non-citizens of the, yeah. Yeah.
I think it's,
well,
of the
yeah.
collateral criminal proceedings.
I think we're making it too I actually think we're complicating it.
Yeah, I don't think it's necessary because it's already
okay. Let's
specific to that practice area.
Louisa, remove the of the, and I'll ask the folks who are moving, do they wish to make any amendments to the resolution?
No.
I'm the second, and I'm Amos. Would you feel it could be clear if we said potential collateral?
Amos just said no. He does. Yeah, Amos just said he doesn't want any changes.
I know, but I'm just, because we call it collateral consequences in criminal. We're not saying collateral criminal consequences. So I know. Anyway, I'll just keep the second.
Fariba?
Could we possibly table this and discuss other resolutions? I just feel like we're rushing it. I'm really concerned about the language of this first version 2. And we are denying access. I mean, I'm just referring to what Judge, you said earlier. My immediate reaction was the same, is that we're denying access based on their immigration status. I mean, I'm by no means a constitutional scholar, but are they a protected class? But what are we doing here? I don't want to receive more criticism of the program if because we're rushing through this. So is there any possibility, because we have other resolutions to consider, is there any possibility we could table this? Judge Yu has a meeting, maybe then we can come back to it later in the day?
We're going to have,
we're only voting on this revision that does not exclude non-citizens.
right, we're not going to, we have to see what happens with this before knowing if there's going to be another motion or not.
Louisa, can you move the other part starting with prohibit off the screens? Just push it down. This is all we're voting on here for even now. So it doesn't exclude non-citizens anymore.
Right, but I'm not comfortable with this language either, and I'm just thinking we're rushing it. So anyway, I would just, that was my suggestion, but if you want to go forward.
We can break, I mean, quite honestly, of course we can do that. Of course we can take a break, but we need to discuss other things in the interim as well.
No, I was just push it back, just table it for now, push it back and get back to it after we're done with other resolutions. That's what I was saying. I wasn't suggesting a break.
Okay, we're going to have to get this dealt with before 1:30 because then we lose Judge Yu again. Ira, do you have more comments at this time?
No, I vote for this resolution.
So Fariba's motion is a motion to table, but it may not be seconded. So if it's not, then we would be able to vote.
So thank you for reminding me of the procedural rules. Is there a second for a motion to table? I'm going to scroll through and make sure I'm not missing any hands. I don't see any hands, and I also don't see any more comments. So I think, Louisa, you can go ahead and take a vote. To be very clear, the resolution that's being voted on is the one that says further resolved that we recommend amending the collateral criminal practice area to specifically require paraprofessionals to be trained on potential immigration consequences for non-citizens. Okay.
Bashan? Let me stop sharing so I can see. Brynelson?
No.
Felmet? Fleischman?
No.
Hamilton? Judge Harper? Hartston?
Yes.
Kirchmeier?
Kimberly, we can't hear you. Was that a yes?
Yes.
All right, I want to be sure I'm hearing you properly.
McGray?
Yes.
Olvera?
Yes.
Robinson?
Yes.
Judge Rubin? Shining?
No.
Sarouche?
No.
Spiro?
Yes.
Torres Ambriz? Judge Wiley?
Yes.
Judge Yu?
Yes, thanks, Louisa.
Let's give Luis a moment to count up.
8 ayes, 4 noes. The motion carries.
Okay. And Eric, I know we're losing you. We'll see you back hopefully soon. Are there any other motions that anyone wishes to make in regards to this area? Or proposed resolutions, I should say, sorry. Okay, I don't see any. So Leah, I think we can move ahead.
Next one. All right, so here's another one where I just proposed slightly revised language. This is the exclusion of surrogate parentage from the family, children, and custody practice area.
And do you want to provide any background on this one?
Just the background was, as noted in the memo, this topic did not come up at all during the many hours of deliberations of the Family, Children and Custody Subcommittee. It was pretty consistently noted in not very many public comments, but in those that did address this topic, that it's quite complex. Also questioning whether there would be, in fact, be a need for paraprofessionals because the folks doing this work, engaging in surrogate parentage, are fairly well resourced. So we did run this by the members of the subcommittee via email. I think there was agreement from those that we heard back from that it should be excluded.
Stephen?
Yeah, specifically, what did Steve Hamilton say about this?
I don't have immediate access to that. I believe that he said it should be excluded. Do you recall, Fariba?
Yes. I mean, we should have really put this in the category of other areas excluded, such as multiple parent statute. It's highly complex. Not even all family law attorneys do this kind of work. So it completely makes sense. And we just forgot.
And the reason I'm hedging a bit, Stephen, is that Linda sent that email out before she left. I saw some of the responses come in, but I don't immediately have access to her emails right now.
I think there was general agreement with respect to the subcommittee that this was an area that we should have excluded and just did not do so.
Then Leah, I'm confused. Why are we proposing to include it?
It's to include it on the excluded list. There's a list of excluded tasks.
Oh, got it.
And the question, so it reads to amend the list of excluded tasks. So that list will include cases involving surrogate parentage.
Got it. Thank you.
And we heard, Friba, was there more that you wanted to say on this?
Me?
Yep.
Oh, no, that was it. It should be excluded. It's just highly complex. Thank you for asking.
And it looks like I'm not seeing any other hands or comments. All right, so Luis, I think you can go ahead. Well, first of all, we need someone to move. Is there someone who would like to so move this resolution?
And which one?
Whichever one you want. I want someone to tell me that they want to move and tell me what they're moving.
Let's see.
So I would move, this is Judge Wiley, I would move to exclude the second resolution, cases involving surrogate parentage.
Okay, so then let's remove that top one.
Include cases. Okay, I second.
And Fariba second. So Monica first, Fariba second. The resolution is to amend the list of excluded tasks to include cases involving surrogate parentage. And Luisa, when you're ready, you can go ahead and take the vote.
Bashan, Brynelson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Hartston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres and Breeze, Judge Wiley,
Yes.
Judge Yu.
And Judge, you remember just left.
11 ayes, 0 noes. The motion carries.
Okay, thank you. Just turning to the. Hold on one second. I just want to get my notes in front of me.
You can put up the next resolution, Lisa.
And I did notice that Angela in the attendees had her hand up. So I would like to, especially since she may wish to comment on some of these, I'd like to give her the opportunity to speak. If you could please just allow Angela to speak for 3 minutes.
Thank you so much. I appreciate this opportunity, and I apologize. I missed the. I had an appointment. The public comment. I guess my comment would be general overall is concerning the fact that we're back here making additional exclusions in the first place. Particularly, I feel like this is a very political thing versus a necessity. I would like to provide insight in my experience. There have been other bills in attempts to minimize non-attorney professionals similar to the paraprofessional, which and there was a lot of support behind them, right? Because we saw that there are certain individuals from the Senate Judiciary who commented that they would vote it down, right? That we did see that political push behind it. However, when the bills did make it to the floor, one of them, which actually successfully made it to the floor, it was voted down. And so, I don't mean to pull away from the efforts in what you're doing right now, but I'm very concerned as a member of the public to see this needed program being pushed back and pushed down and minimized, really because of political strife, right? And we haven't even gotten up and this put forward before the public at large or our representatives, right? And it's being minimized at this point at the state bar, which is why I'm concerned. Why is the state bar should not be overseeing this program, which we saw was an issue in Washington. So the fact that we can't even get launched or off the ground, and you guys are being pushed to come back and revamp and re-minimize this, or to minimize the scope and services, isn't that what the next level's responsibility would be? You guys have already done your work and put forward your recommendations, and then that's their job to revise those. And so I just want to make it very clear, and I thank you so much for this opportunity to speak. I know I missed the public comment section, but this is political, and I just have to make my record how political this is, and it's just ridiculous. I think you guys did a great job. I didn't agree with all the recommendations, but nonetheless, you put forward an amazing, program structure, and the only reason we're here today is political because
30 seconds remaining.
It should be handled at the next level, and but they don't have the cajones, let's say, to do that because of political pressure. And so I'm going to say, if you need me to, I will go and I will sit at the Capitol and I will sit in the Senate Judiciary, okay, or whoever's office you need me to sit in. Thank you.
Thank you, Angela, for your involvement and continued participation throughout this process. It's very helpful to hear from a variety of people, and certainly yourself included. And I will say, though, that as far as what we are doing here today, I think the public comment process is important, and the public has weighed in quite heavily with a large number of comments that many people, including many people on the meeting today, have spent a lot of time going through and give us some consideration and thought about what we've done so far and whether there should be modifications or not. And I think a good example was the last one, right, where it was simply something that the committee had not thought about and that we were happy to have raised for us. But Angela, thank you again for your comments. And Leah, Louisa, we can go back to putting that up on the screen.
So the change here is to modify the the practice area with respect to conservatorship and guardianship to clarify that it's of the person. That was the intent. It got dropped somewhere along the way. One of the public comments, or I think it was one, just questioned whether or not this was sort of an intentional attempt to bring in of the estate, but that was obviously not the intent of the group.
And I agree with this change because there are conservatorship and guardianships of the estate, and it's an important distinction.
Thank you, Fariba. Would anyone else from the Family, Children, and Custody group like to chime in? Okay, I don't hear any chiming in. And let me just do a scrolling to make sure I'm not missing hands, and I'm not missing hands. And so I think, Louisa, once we have a motion here, where do we, I got to scroll back. Okay, Ira, go for it.
Shouldn't we add at the end of this, and conservatorships and guardianships of the estate are not authorized?
Let me hear from someone in the family group. Or Leah.
Well, there's only conservatorship, guardianship of the person and of the estate. So if you say this person is authorized, that means the estate is not authorized. Although I think our list is a list of excluded topics, right? Like we saw in the last resolution. So perhaps our suggestion is consistent with the way we've been addressing these. Leah, what do you think?
So I think it could go either way. We could say uncontested conservatorship and guardianship, excluding matters of the estate. I think it's a little more difficult to wordsmith it right now. And I'm looking in the table that Stephen was referring to, that is provided as attachment B, that lists the entirety of the recommendations, but the practice areas. What it says right now is uncontested conservatorships and guardianships are authorized with the following exception. So I guess, and I added of the person, but we could strike of the person and just add as a bullet with the following exception, uncontested conservatorships and guardianships of the estate.
Well, any uncontested or contested, we don't care, right? Yeah. So maybe to specify that conservatorship and guardianship of the state are excluded.
To specify, okay, so do you want to amend the resolution that way?
do I make a motion to amend it or can I just?
Well, no one has moved this. So
Okay.
Fariba, if you would like to make this, if you would like to move and put forth the proposed resolution, you can go ahead and tell us what language to put in here.
Okay, I move. And my suggested language is to specify that conservatorship and guardianship of the estate matters are excluded.
So,
From the area.
Louisa, first you need to strike uncontested.
Sorry, and
Strike person.
Estate matters are excluded.
And strike, delete the
Yeah,
rest.
don't write this down, but should we add from the areas of practice or just leave it at excluded? I can't decide. Is this sufficient or should we add from the areas of practice?
I think this is sufficient.
Cool. Okay, I move for this then.
Okay, so the resolution and the Fariba moves is that to amend the tasks in the family, children, and custody practice area to specify that conservatorship/guardianship of the estate matters are excluded. Is that correct?
Yes, Your Honor.
Okay, and is there a second?
I will second.
All right, thank you, Amos. Carolyn?
Okay, so now we're allowing, okay, we allowed before conservatorships, and I'm just trying to get clarification.
Sure.
So before we were allowing conservatorships in full, and now we're excluding estate guardian. Okay, there's two kinds of conservatorships. There's one of the person, which is the health matters, and then the guardianship of the estate is the financial matters. So just again, we're going to allow personal conservatorships of the person, which was in the program before, but we're going to carve out conservatorships of the estate. And this is just setting it up, I think.
Right. Is that correct? That's my understanding, but let me ask the people who so move. Fariba?
You're muted.
Man, you would think I'd know how to do that by now. So if I remember correctly from our discussions, we had always intended to exclude estate matters. We just didn't add it to the list. I think it just got forgotten by mistake. But we never wanted, I mean, in all our meetings with subject matter experts, everything, we all decided that guardianship of the estate and conservatorship of the estate should be excluded. Way too complicated. So it's not that we're all of a sudden coming up with this, we just forgot.
I agree. I believe this is a clarification.
It's just one more comment. Okay, now that I understand it, these are always intertwined. It's very, I don't know that there are too many conservatorships of the person who don't include conservatorships of the estate. So when someone is, I'm going to vote for this, but I just think that some people have, Ira has said, and other people have said, this is not something that I think, I don't think this is going to work. This would curtail the ability of a paraprofessional to have help. You might have somebody has to do the conservatorship of the estate themselves. And so you'd get conflicts and you'd get attorneys doing the estate. And so it just seems, I agree that the estate matters should be excluded, absolutely. And I'm gonna vote for this change, but I don't understand. I just think that this is going to make it harder for a paraprofessional and lead to conflicts. Thank you.
May I respond?
Of course.
So in my office, Self-Help Center Family Law Facilitators in Santa Clara County, we help with conservatorship and guardianship of the person only. And there are quite a few people that come in just to do the conservatorship of the person, and they don't want to deal with the financial side of it. And my response to your comment, I think, is a valid concern. It's just those people that just have to hire attorneys. If they want to do it together, then they need to hire attorneys.
And is there anyone else who would like to comment or be heard on this? Carolyn, did your, oh, no, okay. Gotta do my scrolling thing here. Okay, I don't see anything. So Luis, I think you can go ahead and take the vote.
Bashan, Brynelson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Hartston,
Yes.
Kirchmeier,
Kimberly, we can't hear you.
Yes.
Thank you.
McRae,
Yes.
Olvera,
Abstain.
Robinson,
Yes.
Judge Rubin, Shining,
Yes.
Sarush,
Yes.
Spiro,
Yes.
Torres Umbreeze, Judge Wiley,
Yes.
Judge Yu. Ten ayes, 0 noes, the motion carries.
Great, thank you very much. And then whenever you're ready, we can move on.
So this next resolution is a bit more fuzzy. I'll just say the intent behind it. We got a really, I think, compelling comment from Michelle Pistoni at Villanova Law School, and she runs what looks like, I have seen a demo of her program at one point, a really incredible program to train accredited representatives for federal immigration proceedings. And the gist of the comment was that sort of this old model of credit-based and hours-based education is essentially outdated, and we should be focused on outcomes and learning objectives. And I essentially felt that I don't disagree with it. I don't think we have time in our process right now to begin to redraft the entirety of the educational requirements to be outcomes and learning objectives focused, but instead thought perhaps the working group could adopt a resolution that expresses a willingness to have the educational requirements modified ultimately as recommended by experts that are consulted to develop that curriculum. So that's the intent behind this resolution.
Which is not to say, Leah, I mean, correct me if I'm wrong, that's not to say that that couldn't or wouldn't happen absent this resolution, is that right?
That's correct. Although, you know, the working group has adopted a fairly prescriptive set of educational requirements that are very much credit based.
Right.
So, but it could be that the group decides this isn't needed or wants to work with it. I just wanted to share my rationale.
No, I appreciate that. And I'll open the floor for, you know, if someone wishes to move, they may. If someone wishes to just comment, they may. Julie, I see your hand.
Yes, if that is a concern, I would then agree with Leah's proposal, because at least at American River College, we all of our programs are set with student learning outcomes. They used to be objectives, now they're called outcomes. So that would be consistent with what our program does in order to construct the curriculum.
Anyone else wish to comment? Okay, I don't see any comments. Is there anyone who would like to make this motion?
So moved.
All right, thank you very much.
I'll second the motion.
And thank you. And I'm just scrolling to see if there's any further discussion. I don't see any. So Olivia, I mean, whenever we can go ahead, Louisa.
Bashan, Brynelson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton,
Hamilton is not here.
Sorry, I muted myself accidentally. Hardston,
Yes.
thank you. Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres Ambriz, Judge Wiley,
Yes.
Judge Yu.
And Judge Yu's not here, so I think that's that.
11 ayes, 0 noes, the motion carries.
Okay, thanks very much, Louisa.
The next one.
All right, who wants to, Leah or whoever would like to tell us a little bit about the backdrop on this?
Yes, this was a public comment received. I thought that it made sense. It's a recommending amendment of the composition of the Licensing Oversight Committee. And I think in the attachment, we indicated what that would look like. I think it would essentially be one of the Supreme Court appointees.
When you say essentially, would it be one of the Supreme Court appointees?
Yes, it would be. It would be one of the Supreme Court appointees. I'm just looking for the document.
Yeah, I'm trying to pull it up too to see. Okay, any discussion about this?
Yeah.
Go ahead.
I agree with this, but it seems a little fuzzy because it says attorney with direct knowledge of the legal services. I mean, almost any attorney might say. So I think it ought to say an attorney who has been employed in legal services delivery system, blah, blah, blah.
I'm not sure what that means. I'm just, talking off the top of my head. I'm not sure. What does it mean to be employed in the legal services delivery system?
Then that's a good point too.
We could say employed as a legal services attorney serving low or moderate income Californians or just low income Californians.
Yeah.
Or could you just say something? I'm just talking off the top of my head, an attorney who has represented low or moderate income or low income Californians. I'm just trying to make it as simple and straightforward and understandable.
You could do that once, and then you qualify.
Well,
one client, in other words.
I guess what I was going to suggest is that if you're going to talk about how many years experience or something, then we're getting a little bit more in the weeds.
Yeah.
But I think that we're recommending that at least one seat be held by an attorney with experience. I would just say experience in the delivery of legal services for low to moderate income Californians. And that way the people who are nominating them will have the discretion to determine how much experience they would require of the potential candidate. But I just didn't like the employed, because if someone is doing it pro bono, I would want them excluded.
Is the idea here that the attorney has to have actually represented people, or could it be, for example, an attorney who works at a think tank on these issues, for example?
I think the intent behind the public comment is someone who's actually represented people. You have a couple hands up. I don't know if you see them or you want people to just speak up.
Let's see, Fariba.
So thank you. I think it should be more general than represented, but I think somebody who works in a think tank and has no direct experience working with, pardon me, self-represented litigants is a big remove. And I want to exclude representation because somebody like in a sub-hub center or family law facilitator's office we don't represent people, but we have plenty of experience working with the litigants and court users who would be using paraprofessionals to help them. I also, again, I just want to make sure that moderate income people are not excluded from this, because one of the benefits of this program is that it's going to address the needs of the moderate income court users who cannot necessarily afford attorneys, but can pay something, versus low income who may qualify for nonprofit legal aid services if they have room to take them.
Stephen?
Could we just go with experience in the legal services delivery system? I think whoever is making the appointments will understand what that means.
Yeah, the direct knowledge, I have to agree. I mean, I'm not the one moving and I'm not the one voting, but I have to say the direct knowledge doesn't sound great to me. So if it read must be held by an attorney with experience, let's just put that in there for now, and then we'll keep discussing. I mean, obviously there's not a motion yet.
And then strike everything to the. Yes.
Okay. Stephen, did you wish to say anything further right now?
No.
Ira?
Yeah, I'd like to tighten it up some, and here's why. I hear where Steve was going with that, and I like the direction. But if, for instance, this were this were enacted and the decision makers someday were somebody like the Reagan administration in the 1980s, they would say, well, yeah, we got some people with experience in the delivery legal in that system, and they don't like it, and we're going to appoint that person who doesn't like the system. A lot of think tanks don't like legal services. So I really think it should be somebody who has a lot of experience representing or assisting, to address Fariba's point, representing or assisting low or moderate income Californians in their legal services.
Any other hands? And is there anyone who would like to move a resolution, whether it's this one or something modified? Kimberly, I see your hand.
Yeah, we have this a lot with our boards, that they represent different areas when they get appointed. And usually I think the wording, I just looked at a couple of them, and it would be like an attorney representing the legal services delivery system for low or moderate income Californians. I think that's how we would have it in some of our statutes.
Can you say that one more time?
An attorney representing or a representative of the legal services delivery system for low or moderate income Californians.
Okay. It's a little confusing to me what that, I'm trying to think about what this would, how that would read.
It would say something like an attorney
representing low or moderate income Californians?
No, an attorney representative of the legal services delivery system for low or moderate income Californians.
I don't know. I say, it might just be me. I don't understand what it means to be a representative of the legal services delivery system.
Yeah.
May I make a suggestion? This is Dana.
Go ahead.
An attorney with experience delivering legal services to low or moderate income.
Nice.
Well, maybe I'm interrupting, but that bothers me. It's a good idea, but it's too limited because it could be somebody who's only done it once or twice.
Okay, but at a certain point, we also, though, need to put some faith in the people who are selecting. And I think, there would certainly be, it's difficult to put in a qualifier. I mean, if you want to put in with significant experience, I guess, but I mean, we certainly can't put in number of years or number of cases represented. So I think there is some, at a certain point, these elections are going to be made. And if the Supreme Court picked someone who'd done this one time, I imagine there would be appropriate blowback to that, I would hope. But in any event, I'm not going to do the motion. Someone needs to make a motion and decide what language they want in their motion.
Make a motion to approve the resolution on the screen
As it's written or with
as
that?
written.
Okay,
I have confidence the Supreme Court will know what we're talking about.
This is Judge Wiley and I second.
okay, so we have a first and a second. Dana, do you have further comment?
No, thank you.
Okay, if you could pop your hand down, that would be great. I'm not seeing any further comment. Okay, then I believe that we can go ahead and take the vote.
Sean, Brynelson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Hartston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres Ambrose, Judge Wiley,
Yes.
Judge Yu. 11 ayes, 0 noes, the motion carries.
Thanks very much.
The next one Louisa is going to put up is in response to a comment submitted by Dredif. This is another one where there's a proposed amended resolution, slightly different, that the difference is highlighted there in yellow from what was in the agenda item. The Dredif comment generally spoke to the lack of reference to disability issues throughout the entirety of the recommendations. And this was one specific aspect or way in which the recommendations could be amended to address those concerns.
So the staff recommendation is that there be a resolution that
elimination of bias, if we take it the way it is used on the attorney side, there's no explicit requirement that include or address disability-related bias. So this would be a modification for the paraprofessional program.
all right, so that the training, the required elimination of bias training would include disability-related bias along with the others.
Yes.
Okay. Any comments? Anyone want to move? Julia.
I guess I'm just concerned, why are we adding something that is not even required of attorneys?
Well, there is a precedent for that. We have trauma-informed practice, which is not required. I thought this comment by Dredif was persuasive. I think it probably is something that needs to be addressed on the attorney side. And there are many ways I think we're doing things slightly different in the paraprofessional program that might foreshadow what is to come on the attorney side. This isn't an additional hour of MCLE. It's just clarifying what would be included in the EOB requirement.
Okay, any other comments? Would anyone like to make a motion?
This is Dana. I'll move approval of the resolution with clarifying amendments.
Okay, so Louisa, could we please remove the top one?
This is Fariba, I second.
Thank you, Fariba. Okay, and obviously in the actual resolution, we're not going to have highlighting. Any further discussion? I'm just scrolling. I don't see any hands. So Louisa, we can go ahead and take the vote.
Sorry, Brynelson,
I'm going to abstain.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Hartston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres Ambriz, Judge Wiley,
Yes.
Judge Yu. Ten ayes, 0 noes, the motion carries.
Okay, while Luis is getting the next one up, this resolution has to do with clarifying the timeline for finalization of the metrics for program evaluation, another one with a slight modification. And this is really just to emphasize the fact that those metrics will be finalized prior to implementation of the program. I think there's some concern that if they aren't, the goalposts, will be moved once the program is implemented. The evaluation will have less integrity as a result. And that, I think, was always the intent, that the evaluation design would be finalized prior to implementing the program. So I see this amendment as advancing what is sort of a best practice in evaluation regardless.
Amos?
Yeah, I have a question. Who will be finalizing those metrics? I think I was one of the ones, at least, that asked for evaluation to be included on the agenda for this meeting. And I think certainly one of the issues is that it needs to be finalized before implementation. But I think equally concern is what those metrics are, and that they're well thought through, and that it's not really the bar that will be doing the evaluation. So I think it's important to address those issues as well. And I don't know if you've thought about that.
Yes, and I think I'm looking for it here. The recommendation that was already adopted regarding program evaluation indicated that the evaluation needed to be completed by an independent evaluator. So that's already captured. There was an initial set of metrics that was voted on by the working group, and that was included in the report. So that will be a baseline for the program evaluation. I imagine, how these processes typically work, you'll have the expert, who's the independent evaluator, review what the working group has done and recommends. They will recommend modifications, and then who will approve ultimately the contract holder. So perhaps that is the bar, the oversight committee could be the approving entity. That particular aspect was not addressed in prior recommendations or in this one.
So if I could just recommend amendment here, because I agree with the staff's proposal, but again, I think it's not just the timeline, it's the independent evaluation, independent evaluator, I think is important to specify. And again, process-wise, we probably don't need the specifics in here, but I think it usually requires, a whole hiring process and request for proposal. So there's a lot of steps. I don't know exactly the state bar steps in doing that, but I think it's important to identify who that there's going to be an independent evaluator working through the appropriate metrics.
Okay. As I said, the recommendations that have already been approved by the working group do clarify that it will be an independent evaluator. But if you want to modify this resolution to specify that evaluation metrics must be finalized, and evaluation metrics must be developed and finalized by an independent evaluator in advance of program implementation.
Yeah, I think that would be helpful. And I don't mean to be too far in the weeds, but I think who's doing the evaluation and who's designing the evaluation may or may not be the same person. So I think those clarifications would help.
So do we have proposed language?
I think it would be after, if you're, Amos, are we working with the amended resolution with the word must?
Yeah, that's fine.
All right, must be final, must be developed and finalized by, after the finalized by an independent evaluator. I think this is it. And you could get rid of the first resolution then, Louisa.
Carolyn?
Okay, Leah, do you have an estimate for the cost of having an independent evaluator do this? And otherwise, I just don't understand at all why the differences will be finalized or must. Two questions.
We do not have a, I'm just looking in the memo, what I wrote for the memo for today. I mean, for both, neither curriculum development or program evaluation have currently been included in the estimated cost of the program, which was another topic asked to be added to the agenda today. I put both of those together at just in this memo at about 350,000. I think it's reasonable. I think it's certainly reasonable to think an evaluation of this size, $150,000 to $200,000.
And then why is will different than must?
I don't know that there is a difference. I mean, I think it's a question. Yeah, I mean, I don't know. Leah can respond.
I think it's a bit stronger.
But why? I mean, must means, must is totally different than will. I mean, must is, this was originally to say must, there must be a reason.
Well, not to speak for Leah, but when she says that it's stronger, I think if my understanding of the intent behind this, and we'll see if it's correct or not, my understanding of the intent behind this is to make it 100% clear that the evaluation metrics have to be developed and finalized before the program rolls out. Is that correct? Leah?
Yes.
Yeah,
there were a number.
Right.
Yeah.
I just Googled it. It says must is stronger than will, and that was my intention.
Okay.
There's a long explanation of why that is that can be found on the World Wide Web.
I will so
Okay,
move.
thanks.
I will so move for the resolution on the screen as amended.
Okay, thank you. Can we just remove the top one, please, so we are not looking at it? Okay. And just accept these changes. So yeah, it's not highlighted and red and. Thank you. All right, so Amos moves what is on the screen. Do we have a second?
Second.
Thank you, Ira. Do we have further discussion or comment? Okay, I think we can go ahead and take the vote.
Bashan, Brynelson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Hardston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
O'Vera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
Abstain.
Sarush,
Yes.
Spyro,
Yes.
Torres Umbries, Judge Wiley,
Yes.
Judge Yu.
Abstain. Thanks. Well, thanks so much.
Thank you. 10 ayes, 0 noes, the motion carries.
All right, thanks very much.
All right, so while Louise is putting the next one up, so the topic of disclosures generally was added to the agenda item, added here at the request of Amos. And I tried to include it in the memo, what I think will be Amos's recommendation for today, staff's response to that recommendation, as well as address other issues that were raised on the disclosure topic, including by CoProc and its very extensive set of comments on the rules. The resolution that Louisa has put up here is the most tactical of the staff's recommendations, or it is the actual staff recommendation with respect to the disclosure topic. So we received comment to the really in this vein that the state bar or that a form needed to be developed to ensure that there would be standardization, consistency, and comprehensiveness with which the requirements outlined in 1.4.2A2 would be provided to prospective clients. And so the recommendation is that the working group resolve the state bar develop that form and make it available to paraprofessionals at no cost. There's a whole host of other issues out there around disclosures, and I know Amos, I'm sure you want to speak to this. So I'll just tee it up that way for now and get the conversation going.
And Amos, would you like to chime in at this point?
Sure, thank you. So yes, I was the one who asked for disclosures to be included on the agenda. I don't know, Leah, if it's possible to bring up what you had in the memo as a alternate proposal, or actually they might not be conflicting. It might be as an additional proposed resolution.
Sure.
Because I think you had some language, and I can describe it as you're doing that.
I think, let me just be clear for Louisa, you take down what's here, bring up the agenda item, and you're going to go to page 7 of the agenda item. All right, sorry, Amos.
No problem. So just for clarification, the reason why I asked for this to be included on the agenda, I did have a dissenting opinion on this, and I think the staff memo highlights that, and that's the proposal I think that's being brought up. But my understanding of the public comments that I reviewed and the people I have spoken to specifically in legal services is that a major concern is that people who may qualify for free legal services from an attorney through a legal services program is going to be unaware of that and pay for services from a non-attorney. Of course, they have raised additional concerns about, whether there's the price of it, that they can't afford anything, and that the price is too high, especially without fee caps, and quality concerns. But I think we could at least address the disclosure issue, which is a disclosure that there is a free legal services option that somebody may qualify for with contact information. So I'd like to address a couple things because it's a bit complicated at this point. There's 2 relevant disclosure rules, proposed disclosure rules, 1.4.2 and 1.4.3. So and Greg can help me with this, but 1.4.2, which is what the staff is suggesting be a resolution related to 1.4.2, is a general information provided to all potential clients before the paraprofessional has any specific information about what the specific legal issue is, or what their financial circumstances are, et cetera, et cetera. So that would be just a very general, I'm not an attorney, there are limitations on my license, and those kinds of things. The 1.4.3 is the informed consent rule, which is once the paraprofessional knows more specifics about what the legal issue is and whether it's in or outside of their practice, and if there's limitations on their practice that are relevant, they have to provide notice of that. So there's 2 options to deal with any modification of a notice requirement. You could do in 1.4.2, the general notice requirements, 1.4.3, the specific informed consent requirement, or both. Alternatives are in both. In other words, that there are alternatives to hiring a paraprofessional, including legal services. But the question is, how general can that be? And that's why I asked to bring this up. As you can see on the screen now, my proposed in my dissent, my proposed revision was to 1.4.3. So when the paraprofessional has specific information for what the legal issue is, and that the potential client may be low income and qualify for free legal services, that they provide specific information about free legal services that provide that type of practice area and that may be free given their income status. You know, no guarantee that they'll be able to get services, but again, it's just a disclosure requirement. I would also like to address the burden point, because and we can talk a little bit about the state bar's proposal, but they're talking about creating a form disclosure. I think being aware of what legal services are available in your county as a practitioner might require a little bit of work once, but it's not going to be overly burdensome. There's unfortunately not that many legal services in most counties. I don't think it will be burdensome for somebody who has a specific practice area, like they're a paraprofessional in family law or a paraprofessional doing housing law, to know if there is a free legal services option for low-income people in that practice area, and providing contact information. I just don't think would that be that burdensome. And I agree the state bar may be able to compile some information and make it available. So the question is, will a paraprofessional need to provide that information, or can they just say, generally speaking, there is this thing called legal services. You should know that, but I'm not going to, I know there's free legal services available to you, but I don't have to disclose that. I think, so again, it's just not my dissent. Certainly I believe this should be passed, but I do think a consistent message we've heard from several legal services programs about a criticism of this entire program is that people who potentially are eligible for legal services will be unknowingly diverted to pay for non-attorneys. And again, they had some quality concerns and cost concerns, but the idea is we can address that with a disclosure fix here. And I think we can minimize the burden on paraprofessionals.
Leah, do you want to respond, or does anyone else want to discuss?
I think I put the staff's response in the memo. I feel this issue has been really vetted. I think Amos's position is clear. I feel like it's been thoroughly vetted by both the regulation subcommittee and the working group, and there was a decision not to require this level of specificity. So I don't have anything more to add other than that. The working group may want to reconsider it. And I'll just say that in terms of the staff recommendation, it does address 1.4.2, not 1.4.3, because I don't think it's realistic, as Amos, I think, notes, to have this sort of generic form for the 1.4.3 discussion, which is intended to not be standardized, but related to the needs the client is presenting.
Judge Yu?
I support Amos's dissent. And I, with respect, I know it's been vetted, but I just wanted to say that.
Fariba?
I just wanted us to recognize the difference between best practice and a mandate. It is, of course, best practice to provide this list. But right now, there is no mandate for attorneys. There's no mandate for legal services. Once they turn somebody down because of issue qualification or income qualification, or they just simply don't have room, they're not mandated to give alternate resources in the community. Why are we mandating this for this group of people, professionals? I just don't think it's necessary to mandate. We could certainly recommend it at best practice. And this is what we talked about over and over, both in the regulation subcommittee and in the work group. And I suggest that we stay with that. It's just, and it is burdensome, by the way, because you have to update it. I mean, we have a resource list, and if we don't update it regularly, there are for sure telephone numbers that change, things that happen, especially like the pandemic. A lot of services were deleted or provided differently. So there's definitely the burden to update this list. And what happens if they provide a list that's outdated? Are we going to hold them now responsible under this rule?
Thank you. Elizabeth?
Thank you. I know a lot of hard work has been done, and obviously it's all for the end user, which is the self-represented litigant. It has been my experience that when people come to pay for a service, they have already exhausted a lot of energy to try to get their service done for free, whether it's through the court system, family facilitator's office, or that also do evictions. And then when they come to you, they're already exhausted of being turned away, doors closed in their face. And they're aware of those free services that take forever to pick up the phone, or maybe they're inaccessible because you're only able to chat with them between the hours of 1 and 3, Monday, Wednesday, or Friday, but not on a leap year. And I'm just, saying that to highlight the struggles that these people come to you with, and they're begging you to take their little money that they have because they just need help. And so I know a lot of people who do provide resources and referrals to the Bar Association so that they can get either free consultations or low cost. I agree with Fariba that I think it's a best practice. I think it's a practice that's happening with some professionals already. The other thing I would mention is my recommendation would be that any disclosure, and I have mentioned this before, so I'm just mentioning it again, that any disclosure like this, whether it's done by the State Bar or done by anyone else, that it include that there is an availability of, besides just legal aid programs, that there are legal document assistants out there who are authorized by Business and Professions Code Section 6400, who can provide the typist services or form preparation that maybe is needed. So that's what I wanted to say. Thank you.
Thank you very much. Thank you, Elizabeth. Ira?
I'm in favor of this. It's true there's some burden, but I think somebody who wants to be a paraprofessional should be required to undergo that burden. It's a good point that lawyers aren't required to do it, but I think they ought to be. Point. I guess that's it if I can't think of it.
Thank you, Ira. And Kimberly?
Yeah, I just wanted to back up kind of what Fariba was saying and say I agree with everything she said. And we already have in there that they're required to notify them of the services. What the difference is putting together that whole contact list of information in that county. And that's where we definitely did not agree with that part of it. We do think it's burdensome to the individual, and also just keeping that updated. And by having it in here, as Fariba said, there is a difference between a mandate that they can get in trouble if they don't have this updated, and it changes all the time. So that really was why we thought it was better at best practice. And we heard from individuals that they were already doing this. And so that's why we said no. And so I would just advocate for not putting this in there.
And also, what are the potential ramifications if one does not? Amos.
Thanks. I just wanted to briefly respond to some of the points raised. So I think one of the critical comments, I think, that we received in the public comment period is clarification that the proposed paraprofessional program is supposed to work with legal services, not compete with legal services. And again, the idea is filling in the gaps. And I think that is the right model, that this is not supposed to be for people who could get free legal services and just are not aware. So while I totally agree with the comments that, legal services needs to be better funded and more available, and that people do struggle to obtain those services even when they qualify. Here, this is a disclosure point. This is just making sure people are aware that is a possibility. Not everybody has access to that information. And so it's just to make sure the paraprofessional program works along with legal services and that people are properly informed when they're engaging paraprofessionals.
All right, thank you. And we have, I mean, obviously, this is a very important topic, and we've had extended conversation before today. I do see, let's give Angela 2 more minutes. If you could allow Angela from the attendee list 2 minutes. Angela, are you there? And you're on mute. Maybe she's not there right now. Okay, so let's then go back to our discussion. As I was saying, you know, we've had a fulsome discussion before, and these are important issues. What I would like to know at this point is is anyone actually making a motion with a proposed resolution that we can discuss?
So I would like to move what was just on the screen from the red lines to the proposal, that those red lines.
Let's pull that back up.
I second that, Fleischman.
So this is a red line of proposed rule 1.4.3, and I move that those red lines be made.
So I'm actually having a hard time seeing it. Is there some way to, expand the size on that? Because all we need to see, scroll down. Okay, so hold on, this would be to modify it to say not just free, but also low cost. So it would read that free or low cost legal services may be available to low income individuals from a legal aid program or nonprofit organization. If the client qualifies, with contact information for such organizations in the county. So not contact organization for organizations that are outside of the county?
Again, that might be a best practice and people could do this, but this is sort of the minimum required is the count. Usually legal services are by county.
Okay. And how would, I'm just curious, like if you were to put together a list like this today, Ira, how would you go about doing so for your own county?
Oh.
Not Ira, Ames.
So, you know, I will separately encourage the bar to put this together. And again, I think that is what Leah is contemplating when we get to the separate resolution about 1.4.2.
Right.
But again, for most counties, it's not very difficult. There's going to be one provider, LSC provider. There might be an IOLTA provider. So the bar has an IOLTA list, IOLTA funded organization list. There is an online resource, but it's not easy for individuals. I think a paraprofessional could put together this list in under an hour, and maybe much less than that, especially if it's limited to the practice area. So again, at this point, the paraprofessional should know if they're a family law practitioner and the local legal aid provides family law services, and it's a low income client, that there's just probably one phone number they need to provide.
I'm not reading this. I just want to be very clear on what your proposal is, which is why I'm asking you these questions. I'm not reading this proposal as being limited to within the practice area.
So again, for context, 1.4.3 is the informed consent rule. So this is when the paraprofessional has information
right
about what the legal issue is, and providing information about disclosure of other available choices. So rather than the paraprofessional could provide these services, or free legal services might be available from the legal aid down the street, here's their phone number. That's the intent.
Could I hear, I want to hear from Ira, but also to have a complete conversation. I don't know if Fariba or someone else can give us any indication, for example, a mid-sized county, I mean, not Los Angeles County, which I think is going to have far in excess of a handful of available alternatives. But for example, where Fariba is, how long this list would be?
We have our resource list posted on our website. It's quite long. I mean, we've got many domestic violence agencies. We've got several agencies that provide low bono or pro bono family law assistance. Not that they're taking clients, but we have them on the list. We've got a few that offer assistance in UD cases, especially now with the, COVID protections lifted and so on. So it's quite a long list. And I think that saying that a paraprofessional could do this really easily is discounting how difficult it is, because I have to assign somebody and they have to call, because not all the time you'll find the details on their website in terms of, what they do. Do they still do it? For example, our bar association, we can't, as a court, we cannot refer to specific attorneys. We always refer to the Santa Clara County Bar Association in terms of for pay services. Well, their phone number doesn't work anymore. We didn't know that. They didn't announce it. It's not on their website. It's just we found out from people telling us that doesn't work. So it's more burdensome than you give it credit. And I really applaud the reason you want this done. I just think it should be mandated. I mean, it's just not fair to these folks. We're already, tying their hands behind their back and blindfolding them by having all these regulations. We're making it really hard for them to practice. And it's just removing the motivation to be licensed and regulated versus if the legal document assistant legislation doesn't sunset or is renewed, they're going to do that. They don't have to follow any of these things. It's great best practice, just to repeat myself, but let's not mandate it.
Ira?
Yeah, two things. First of all, in the smaller counties, the organization might be in a nearby county. So I would say that we ought to say organizations available in the county.
Okay, well, that's between you and Amos as the authors here. You two tell me how you want this modified that you can agree to.
I'm fine with that modification.
So could you please indicate to Luis exactly what to do here?
Organizations available in the county. No, available to persons in the county, sorry.
Okay, I can't modify this PDF, so.
Okay.
Let me.
Good PDF program.
I'll type it out in a Word document.
All right, let's give Luisa time to do that while you keep discussing.
And then I'll drop this for the moment.
No, we can continue to discuss while she's working on typing this up, and then we'll come back to you for how exactly you want her to modify it.
All right. I'm thinking the concept is contact information. This is to relieve the burden somewhat. Contact information provided by X for such organizations. Because it is hard for each person to try and find. So if we have maybe the state bar would do it, maybe the legal services office serving that county would do it.
But I want to be clear. It's my understanding from Amos, correct me if I'm wrong, that your intent here is that the individual paraprofessional have this responsibility.
So I do think the bar should put together the list and maintain the list that paraprofessionals could use. And I think, I don't know if you want to jump ahead, but I think that is what Leah is suggesting in her proposal for 1.4.2, so that there is a maintained list by the bar of these organizations. And I do think that would be the best way to go to relieve the burden on the paraprofessionals.
Well, I wasn't suggesting that this be changed. I wasn't suggesting that the information would not be given by the paraprofessional.
Yeah, but the question is, who's putting together the list? Okay, and is it the paraprofessional's responsibility to, as Fariba indicated, call around, make sure that the phone numbers are correct, make sure the contact information is correct, identify, and I do not think it will be one or two in many places, the potentially long list of alternatives for people to go to. I mean, that's really the way that this is currently written. It would be the paraprofessional's responsibility to have put together the contact information for such organizations in the county.
Yes.
Yeah, and just to clarify, I am not suggesting in my recommendation for 1.4.2 that the state bar put together that list. I chose 1.4.2 in part because I don't think that that list is required under it's a more generic conversation. So there is you should, I forgot the specific language, but the paraprofessional should be made, the prospective client should be made aware that there may be alternative choices, not providing specific contact information for those alternative choices. That being said, on our website right now, we link to something called lawhelp.org. And there are these drop downs of legal service providers by county. I don't have a really good handle on how comprehensive that is, how accurate it is. I don't know. Fariva's shaking her head. That's my
we just found some
suspicion.
inaccuracies there.
Yeah, that's
completely
my
relevant here.
Yes, so that's my suspicion. I just wanted to jump in and clarify.
So let's get a clear resolution here. Amos, I believe you were the first on this. So could you please indicate to Louisa how you would like this modified?
So I will accept Ira's friendly amendment, which I believe would change the last line to read with contact information for such organizations available to persons in the county. Is that right, Ira?
Yes. Now, may I suggest another friendly amendment? Maybe you don't think it's so friendly, but information provided by the state bar or a legal services organization. Provided by.
So I think that makes it overly complicated, but I do think maybe in a separate proposed resolution, I would certainly support a resolution indicating that the bar should be responsible for maintaining a list of these organizations and make that available to paraprofessionals.
Okay, but that would be a separate motion. So let's.
I do have a reason for including it in this. It could be a separate sentence in this, but there's a good point made by Fariba and a few others that this is somebody could get penalized, a paraprofessional could get penalized for not doing this. And so they ought to be, the requirement ought to be that they get the information from a list provided by somebody. And I'd say the state bar or the Legal Services Corporation organization serving the county.
So I think that's going to complicate things. I agree with the concern. There is some burden here and some potential consequence. This would both be a rule of professional conduct, as well as a consumer protection. So I do think people would only get penalized if there was some real abuses, not a mistake in a phone number. But again, that's the discipline system that we're talking about, right? We're talking about a rule of professional conduct and a consumer protection.
So to be clear, Amos's proposal does contemplate that it is the paraprofessional's responsibility. While Amos, I completely understand that you would support the bar having the burden of doing this. We can discuss, that's a separate thing. But as this stands, it is the paraprofessional's responsibility for putting the information together. Understanding that that is what this says, Ira, do you still second this? You do. Okay, so I want to make clear that we're all on the same page here. So we have a first, we have a second. Do we have further discussion? Would anyone else like to be heard? Who has, anything you haven't said already that you want to hear? Okay, I don't see any hands. So, and I don't hear anyone. So Louisa, why don't we go ahead, and we will after this take our lunch break. But Louisa, let's go ahead and take a vote.
Sean? Reynoldsson?
Abstain.
Felmett? Fleischman?
Yes.
Hamilton? Judge Harper? Hartston?
Yes.
Kirchmeier?
No.
McRae,
No.
Olvera,
No.
Robinson,
Abstain.
Judge Rubin,
So Judge Rubin, yes, he is with us. But you know what? He's in the attendees. He texted me quite a while ago that he's been online, but I see him in the attendees. So let's move him into the panelists, see if he needs to make any comments, since he obviously hasn't had the opportunity to do so, and let him vote. David, are you there?
Yeah, all right.
Hi, and do you wish to make any comment, or are you ready to vote?
I said yes.
And I'm sorry, is your vote a yes or no?
Yes.
Shining,
Yes.
Sarush,
No.
Spyro,
Yes.
Torres Ambriz, Judge Wiley,
Yes.
Judge Yu.
Yes, thanks, Louisa.
Eight ayes, 4 noes, the motion carries.
Okay. And Leah, is this an okay pause point, or is there something you'd like to do before we take our break?
Well, if folks think we could do it quickly, this is not directly tied to the staff recommendation about State Bar developing the form under 1.4.2. So I just don't know if that's going to generate a lot of discussion. I would think no, but I could be wrong. If not, I think it would be a nice thing to take up.
Endpoint for the morning. Okay, so let's put that up and see where we are. And you know,
Louisa is the previous one. Yes.
Okay, and Leah, do you want to say anything further about this? We went off on another path, so.
No, again, this is the disclosure. This is the disclosure that would take place before the paraprofessional has a significant amount of detail and information about the problems that the prospective client is presenting. And just the recommendation here is that the State Bar does develop a disclosure form and make it available for free.
Okay, anyone wish to so move or have comment about this? Kimberly?
This is, I definitely move. This was something we talked about in our committee when we met, and we suggested this when we were talking about it. So thank you, Leah. This is great. So I definitely move this one motion.
Second.
And Louisa, did you get the second?
Fleischman.
All right, thanks very much. Is there further discussion regarding this? And take a quick scroll in case someone's being shy, but put their hand up, because you know it's a very shy group in general. Okay, I think we're ready for a vote.
Sean, Brynelson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Hardston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
I said yes.
Shining,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres Ambriz, Judge Wiley,
Yes.
Judge Yu.
Yes, thanks so much.
14 ayes, 0 no, the motion carries.
All right, so Leah's prediction was correct. And with that, it's 12:20. How about we resume at 1 o'clock? Okay, and I know, Erica, that only gives us a half hour with you, but we'll take what we can get.
Justice Patrick, can I just make one quick comment?
Sure.
I think I would like to move after the lunch break for a resolution for the State Bar to maintain that list we were talking about in support of 1.4.2. I think it might, I just want to mention that because over the lunch break, we can probably draft some language and the State Bar can think about it. I'd prefer if there's a staff recommendation about that, but I'm happy to put something together.
Yeah, if you don't mind putting something I imagine it won't be that lengthy. So if you don't mind putting something together that you email to Louisa and Leah, that would be great and much appreciated. And I'm sorry, I can't send you a sandwich while you're doing that. All
I
right.
have some additional resolutions, Justice Petro. I will endeavor to do the same.
All right, thanks very much. And we will take Amos's when we get back, but then we're going to go back to our regularly scheduled programming, and obviously Stephen will then wrap around to you. Okay.
Thank you.
All right. Thanks very much.
Okay, we are now resumed. Give me one moment. Can you all see my screen okay?
Yes. So Amos, would you like to talk us through this?
Yeah, just based on the last discussion and vote about disclosure requirements and the burden on paraprofessionals, I do think it would be of assistance for the bar to put together a list that paraprofessionals can rely on. This is also consistent with the bar's proposals for other proactive measures to support paraprofessionals. So I do think it would be helpful to do this list. So the idea tracks the language of the resolution related to 1.4.3A2 and says that the state bar will develop a referral list of free and low cost legal services available from legal aid programs and nonprofit organizations with contact information. I think by county and practice area will be helpful. So by county and practice to support the disclosure requirements of 1.4.3A2 and that it be made available on the state bar's website.
And so are you formally moving?
Yeah, I'm happy to formally move for this resolution.
And do we have a second?
Second.
All right, thank you, Stephen. And any discussion or comments?
So I'll just make a comment. Right now, we fund LAC, Legal Aid Association of California, to stand up this site called lawhelpca.org. I mentioned it before we broke, and I just got a little bit more information about that. I don't believe that this site has low cost providers, and I think that would need to be defined because it is really I think that's a problematic aspect of this proposed resolution. And my team believes that the only programs that are currently listed on the LAC site are IOLTA funded, so a limited set. It's not the entire universe of legal service providers. I say that to say I'm not confident that this is very doable. Just the entirety of the universe of legal service providers that are out there beyond those that we fund is question one. And then question two, there is no definition of low cost. And when we were trying to research low bono rates, at one point when you all were considering fee caps, we couldn't even get a handle on how many sort of low cost or low bono programs there were in the state. So I'm just concerned that we are being set up for failure. Happy to continue to contract with LAC to perhaps increase that contract to beef up that site, but I don't know that it's going to cover the entire universe of who is referenced here.
Yeah, Leah, I defer to Amos, but I don't read this resolution as requiring the state bar to create a comprehensive be-all end-all list. I think we're just asking the state bar to devote some resources to maintain a list, which it sounds like you already do in one form or another. Is there a language we could add to this to make it more palatable to you?
And Amos, do you want to chime in while Leah thinks about that question?
Yeah, and I would invite the same question if there's any modifications. I do agree with what you're saying, Leah, in terms of what the bar currently does. Wouldn't cut it. It's not sufficient, so there would need to be additional resources. And I don't see any problem with contracting it out with LAC or One Justice or the Access Commission. And I do think it would need to include non-IOLTA programs. That is a limitation of what the bar currently does, limited to, so that just for everyone's understanding, there are certain legal services programs that receive funding through the bar, through IOLTA funding. And this would be include that plus. But I would be happy to modify this to include some language that makes you more comfortable. The idea would be to just have the state bar support paraprofessionals in their disclosure requirements.
Carolyn?
Thank you. Yeah, I'm with Leah on this one. It's too hard. The definitions aren't good, but also in addition, the state bar has gone through a lot of work to develop certification programs, referral certification programs. Those are very complicated. They have quite specific standards. So to just say we're going to put together a referral list, also you might be in conflict with those, in competition with those. You might have the same antitrust problems that we talked about with regard to those programs who very carefully meet state bar certifications, and the state bar currently regulates that. So I would be against the way this is phrased. We have an IOLTA list. We're going to make, those other recommendations. So this is very complicated, and it's a last minute thing that I think really it complicates things in ways that we've already talked about.
Thank you, Kimberly.
Yeah, I know we've already passed the prior resolution, but all of the things, that Mr. Fleshman just said, this isn't an end all to be all. All these are reasons why the prior resolution is such an issue to require these individuals to have something. If we can't expect the bar to even have something, or a company that's going to be charged and hired to have something, I'm still concerned about requiring it for paraprofessionals to have it and to know it, and to be then subject to disciplinary action or any type of violation for having it. So I just can't not say that.
You say whatever you need to say. Stephen, did you wish to make further comment right now?
No.
Carolyn, I think your hand is up as well still. Leah, do you wish to respond at this point, and including?
Yeah, I was gonna say, I think the low cost is really problematic. If we wanted to say modest means panels administered by county bar associations, that puts some parameters around it that we could then, go through the 58 county bars and identify who has a modest means panel. So I would really strongly want to encourage us to modify the resolution to be more specific there. On the free legal services beyond IOLTA, as far as I'm aware, there is no comprehensive list of those, and I'm not exactly sure how we would find who all of those providers are. So perhaps some language that set a referral list to include at a minimum IOLTA funded or state bar funded free legal service providers, because we are funding some non-IOLTA programs with some of the new grant money that's come out, and county bar association modest means panels that might, be more reasonable. So referral.
Leah, what about adding the word non-exhaustive before referral?
That's good too. But I still would like a definition of low cost. Okay.
Yeah, I'm with you on that. I'm just trying to deal one at a time. If we add the word non-exhaustive,
there's a hyphen, Louisa.
Yeah.
and then instead of low cost, add modest means
I think we'd say free legal services, free legal service providers and modest means panels, maybe.
Sure.
Panels, Louisa, not providers. And I also just want to ask, would this resolution as written allow us to build out the relationship we have with LAC such that there's a link from our website, but it's not actually on our website?
Sure.
Okay. I think it works, made available. Carolyn has her hand up.
Okay, yeah, my hand up's for real this time. This only makes it worse, folks. This actually allows the state bar to pick and choose which ones it likes. It says non-exhaustive. That is extremely concerning. We have referral lists. We have an IALTA list. We have certified referral entities. This is absolute, you're playing with fire on this one. And I know it sounds good and nice. And we made the disclosure and the other disclosures that Amos wanted, and those were very particular and very helpful. This one is playing with fire so that the existing certified legal referral services already have state bar certification. And now basically you're saying you can have this other list, especially if it's, you know, connected to the state bar website, giving, you know, kind of an imprimatur. Are these companies going to, are these entities going to be private companies? Are they going to be profit? Are they going to be nonprofit? Will the state bar be required to give them certifications like it does? This simple language is, we already discussed a lot of these problems. Competition, free market. This, you know, at 114 on one of our last meetings, or the last meeting, we're going to throw in antitrust concerns from the referral of entities that are not regulated. I think this is worse.
Kimberly?
Yeah, I agree with Carolyn. I'm also afraid that it would be looking like a referral service from the state bar. And, you know, we don't know anything about these companies that you'd be putting on this list. So I have some concerns with that. And then who's behind these services? Is it like a state bar, or I mean, a bar association? Get in there and on conflicts of interest, just have some concerns on that side too.
Nicole?
I just like to, if there could possibly be a disclaimer on the bar's website to say, we don't advocate, I'm not sure of the language, we don't advocate for any of these agencies. But as a consumer, I would like to have, or to see a list, because usually, you know, it's just so hard to find certain services. So it would be a nice added piece as a consumer to have a list that I could refer to. But maybe as a disclaimer on the you know, that we don't advocate, there's nothing advocated for any of these organizations, whether they're nonprofits or, that was just my comment.
Thank you, Nicole. Amos?
Yeah, I'm fine with these proposed revisions and the disclaimer idea. I will say, and Leah, this is really directed to you. I don't know if you have proposed changes to the modest means panels, but my understanding is there are some you know, sliding scale services out there that because they're not free for everyone, they don't get IALTA support, but they are low cost. They could be free. They're nonprofits. They might have a small charge, and I'm just afraid that this language might exclude them unnecessarily. But again, I defer to what I think what you're saying is having LAC do this. So LAC is the Legal Aid Association of California that already contracts with the state bar to put together lawhelp.org, which includes a referral service. And I don't see any problem with, you know, just expanding that relationship to expand the list to support paraprofessionals.
Judge Rubin, please.
Thank you. Just on some experiences I've had here locally with our court and our bar and stuff, I'm assuming built into this is some method to refresh the list rather than give out a list that isn't up to date, which can be worse for consumers than no list. Am I right in making that assumption?
So if I could jump, yeah, I mean, Leah, I think it's more directed to you, but I mean, I think it is important to acknowledge that while certainly I expect that if the bar did something like this, they would do some regular maintenance. It's not going to be, I can't imagine someone whose ongoing day-to-day job it is to update it on, a daily basis.
No, but at least quarterly probably, or at least twice a year.
Leah, do you wish to chime in?
Yeah, that's certainly not what's being done now, is my understanding. I think the group can make its recommendation. I just do want folks to consider the resource implication and the feasibility, given the broad nature of the types of organizations and entities and providers that are contemplated to be on this list. So I would say at a minimum once a year, and that, I think is reasonable. I don't know about quarterly.
Judge Yu?
Thank you so much. I would agree that maybe we could add in the modest means language that Leah said would make this more doable. But we give out lists a lot in treatment court all the time of resources. I have piles of things and all organized. And most of those lists now have people's websites on them. So you don't really have to update the phone numbers all the time. People usually have a phone. If they don't, with people who are homeless, we get them free Obama phones, and they can go on their phone to the web page that is responsibly kept up by the entity, so that we don't really have to update things as much as I used to when we first started doing this. And while I have to leave soon because I have a calendar and because I lost my afternoon coverage, I wanted to just say I support this motion. Thank you.
Thank you, Erica. Nicole, did you have something else you wanted to say? And Carolyn?
It keeps making it worse. I think I've done the LA County Bar low modest means programs for people with conservatorships. I think that's very important because some conservatorships are, I've done that. And they also have sliding scale. It's very important. I think those places are very important, but to allow the bar to seal in now for 1 year review for a whole year. And, will these be professional? Will the state bar receive a grant in exchange for these? Will we know about the selection process? There is a phenomenal, will Zoom be allowed to be one of these if it hires paraprofessionals? Again, this is unbelievably broad at the last minute. I don't know why this is being thrown in here. It is absolutely admirable for Judge Yu and other judges to have handouts and brochures that they can make sure and keep up in their courtrooms. Absolutely wonderful. Absolutely wonderful. And I participate in low bono programs in Los Angeles County Bar. I just don't think this idea of the state bar having a list with links is really something we need and want when we actually do, Nicole, have so many resources for people. I really strongly against this.
I'm going to turn back to Erica because I know she's leaving us sadly in a few minutes.
Thank you so much. I neglected to say that if this is meant to be our last meeting, it's been a true privilege to work with all of you. I have so much respect for Justice Petru, who's got us through all of this, and Leah and her staff. I miss Linda, but really all of you, I have so much respect for all of you, and I really appreciate being in this room with you. And I'd like to call the question, but I do see Ira has his hand up. So thanks everybody, and take good care.
And Erica, we cannot thank you enough. Ira?
What if, to address what Carolyn is saying, we put in here somewhere, subject to state bar referral, what is it called? Referral program rules and antitrust law.
Maybe like subject to statutes and rules governing lawyer referral services and antitrust,
Sure.
something like that. So would it be like a semicolon at the end that says implementation of this recommendation is
Yeah,
subject to?
Yeah, new sentence, I'd say.
Okay.
No, I don't know that it's necessary, but I defer to you and I'm happy to take that friendly amendment.
You mean because it goes without saying?
Yeah, that the bar is going to follow the laws, yes.
Well,
Ira?
I think it's a good idea to
Yeah, Leah, if you would like that language, do you mind just saying it so it could be added?
I could, yeah, but I do tend to agree with you. In general, we can't implement anything that's illegal, or we have to do it within the parameters of the law. So I'm not sure it's necessary either. I like the overt recognition, but I don't know that it's necessary.
Judge Wiley?
I was just going to ask, do we have to have that this information be made available at no cost on the State Bar website, or just that? Because it sounds as if, and I need maybe perhaps clarification, is it that we're voting that the information will be placed on the State Bar website, or does the State Bar have an affirmative duty to make that information available to individuals who need it? And I guess that's the clarification part.
Leah, do you have an opinion? I just tracked the prior staff recommendation for 1.4.2 language.
I guess I think I'm not seeing so much the distinction, Judge Wiley, meaning if we didn't provide it on our website, I'm not sure how we would provide it. I guess we don't need to specify the vehicle by which we will provide it. But I don't have a concern about having it there. I think that is in fact how we would provide it, through a link on our website, as I wanted to clarify, not putting that directly on our website.
So I was going to say, can we just say in the resolution, and then the information will be placed on the State Bar website, or placed on the website via a link or something of that nature in the resolution?
Sure, we could say that this information can be, and that this information is accessible.
That's fine with me as well.
At no cost. On or through, or.
I don't even think you have to say at no cost. It's just is accessible on the State Bar website.
There've been a number of modifications made. Can I please get verbal confirmation that the people moving this are fine with it as currently written as modified?
Yes.
Yes.
Okay, any further discussion? Let's go ahead and take the vote.
Bashan, Brill Nelson, sorry.
Yes.
Felmet, Fleischman,
Yes.
Hamilton, Judge Harper, Hartston,
Yes.
Kirchmeier.
Abstain.
I'm sorry, what was that?
That was an abstain from Kimberly.
McRae,
Yes.
Olvera,
Abstain.
Robinson,
Yes.
Judge Rubin,
Yes.
Shining,
No.
Sarush,
Abstain.
abstain, I'm sorry.
Yes, that was an abstain.
Thank you. Spyro,
Yes.
Torres Ambrose, Judge Wiley,
No.
Judge Hume.
Yes, thanks, Louisa. Bye, everybody. Take good care.
Thanks so much, Erica.
Thank you.
8 ayes and 2 noes. The motion carries.
And Stephen, we did receive your proposals. As I mentioned, I'm going to put them a little bit later this afternoon so we can get back on track. Leah, can you move us ahead?
Yeah, we only have one more resolution to address from this agenda item. So Luis, if you could put that last one up. So this is really just an attempt, as noted in the memo. Obviously, these several commenters commented on the rules, but these two organizations or entities spend a tremendous amount of time providing detailed comments on many of the rules, COPRAC in particular. So I want to recognize that, but my recommendation is that we not attempt to address the full body of that work at this time, given that the exact design of the program is still very much in flux, needs to go through both Supreme Court and legislative approval for starters. So this resolution is intended to recognize the fact that we did receive a significant number of comments and that the working group does recommend that those comments be fully addressed in the final set of rules that are proposed ultimately for this
Leah,
initiative.
if I can jump in, if my understanding is correct, and if my review of all of this is accurate, some of the comments in there have been addressed. And then some, some of the comments are contrary to votes already taken on various issues. And that does leave some other ones. Is that correct?
That's correct.
Okay. And this is obviously not a required resolution as far as necessary to move the recommendation forward to the State Bar Board, but given the volume and work that went into it, you do intend to, whether we pass this resolution or not, encourage a fulsome review of all the comments set forth by COPRAC and the LACBA. Is that correct?
Yes.
All right. I just want to make sure my understanding was correct before I opened it up. Stephen, I see your hand.
Yeah, I'm generally in favor of this. My question for Greg is, in the final clause, do we want to make reference to comments to the rules also?
Where would that, I'm sorry, Stephen, I may just not be tracking intelligently. Where would it say that?
I would just add "and comments" there too at the end.
Oh, I see. So you're saying like the comments to the rules. Sorry,
Yes,
my brain short-circuited for a second.
That's okay. I'm referring to Greg, correct me if I'm wrong, but just as we have comments to the rules of professional responsibility that govern lawyers, we're going to have comments to these rules, and that some of the LACPA and COPRAC comments could be addressed in the comments rather than the rules themselves.
So it would say something like, as part of the State Bar process, to issue the final set of rules and accompanying comments for public comment.
Yeah.
That seems fine to me.
Comments, plural. Okay. Yeah, just from my brain, it works better to stick it in there rather than at the end of the sentence. But obviously, anyone else should feel free to modify it. Before we take further comment, if there is any further comment or discussion, would anyone like to move this resolution?
So moved.
Okay, thank you, Stephen. And do we have a second?
Second.
And who was that? You, Kimberly?
It was, yes.
Okay, thank you. It tells you how much time we've spent together that I actually don't need to see anyone's face at this point to know who's speaking, which is nice. I like it. All right, so we have a first and second. Is there anyone who'd like to comment, discussion? Stephen, was there something else you wanted to say?
No, there isn't.
Okay, Amos.
I would just like to thank COPRAC and the LA County Bar Association for their detailed comments. I think they were very thoughtful and I think will be very helpful in finalizing the proposed rules.
I agree.
Yeah, could not agree more. Okay, why don't we go ahead and take the vote?
Bashan, Green-Elson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Arston,
Yes.
Kirchmeier,
Yes.
McGray,
Yes.
Olvera,
Abstain.
Robinson,
Yes.
Judge Rubin,
I said yes.
thank you.
You're welcome.
Shining,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres Breeze, Judge Wiley,
Yes.
Judge Yu, absent. 11 ayes, 0 noes, the motion carries.
All right, thanks so much. And Leah, that was it as far as your agenda, is that correct?
As far as this agenda item, we have one more agenda item, but I think it is the right time to take Stephen's resolution.
That was going to be my recommendation. So I don't know how we're doing this. Stephen, why don't you lead the charge?
Louisa can put them up.
So I made a point in my dissent about concern about the cost of the implementing the paraprofessional program. And there were many public comments on that subject. And on page 7 of the staff memo, I'll just read it. It says the CPPWG could consider resolving that no funding could or would otherwise be used to support the state bar discipline system be used to fund the paraprofessional program. I was expecting to see that resolution on page 10 with the other ones, but I didn't realize until today that it wasn't among the resolutions proposed. I don't know if that was intentional or an oversight, but either way, I think in light of recent events and the recent audit by the auditor of the disciplinary system, I think we should say the money for the paraprofessional program will not divert resources from the disciplinary system. I'm not wedded to the wording that I put together in 2 minutes while I was trying to grab something to eat for lunch. I tried to track the language in the staff memo, was my only intent, but I think we should have a vote on this.
Could I hear from Leah about, I completely hear what you're saying, Stephen. It's just when I'm reading this, I'm not quite sure what it means in the sense that funding that would otherwise be available to be used. I don't know if that means the entirety of the state bar funding. I simply have no idea how this works and therefore what the implication of this language would be. And so I would like to turn the microphone over to Leah.
Yeah, that's the only part of this that I would ask to have modified. Could or otherwise be available to be used. I'm thinking for example, sort of one-time monies that might be available to us that we could use to fund initial implementation of the program, even a general fund loan to support the program. I think that's one reason I didn't make the recommendation, because I'm not sure if it would cover that. When I say general fund, I mean the state bar general fund from our fund balance. So
Leah, put language up there. I was just trying to track the language on page 7. That's where that language came from.
Julia?
Maybe if you want to, Louisa, could you put page 7 of today's memo on the screen?
That's okay. Let's leave this so that she can wordsmith it. I'll work offline over here on maybe some alternate language while we hear other comments.
Yeah, let's do that. Julia?
I would just leave it with from funding that would otherwise be available to be used to support. I would just say from funding that would otherwise be used to support the state bar's discipline system. I mean, if that's too much of a blanket statement, but I understand, but the could to me really sounds problematic.
Right.
I'm fine with that,
So
Julia.
let's set that up. Louisa, if you could please go into the document and strike could or, and then strike otherwise be available. From funding that would remove two. Okay, so now it reads that no funding for the implementation or maintenance of the paraprofessional program will come from funding that would be used to support the state bar's discipline system. That's what we have right now. Julia, was there something else you wanted to say before I turn to Ira?
No, I like it. I prefer that. Thank you.
All right, thank you. Ira?
I like the idea of this, but I need more info about how the state bar is funded. For instance, each year when the legislature approves or doesn't approve, well, when they do approve money for the state bar, is it a single amount they approve? Do they divide it up into how it should be used? If it's a single amount, I don't think we can do this. We can't do it with this language anyway.
Well, how this would work is there's a licensing fee that's authorized, but then there are many other funding sources for the bar. So we already have a number of discretely funded programs, like our legal services staff and that work. There are multiple grant funding streams. They are a whole entire Office of Admissions, all of the costs related to law school accreditation, the bar exam, the first year law students exam, that's all separately funded and accounted for. So there would be a separate funding stream to support the paraprofessional program. Ultimately, that needs to be the licensing fees paid by paraprofessionals. Those presumably would be authorized and set by the legislature, but they would go into their own fund. We have enterprise fund accounting, many different funds here. So I think we are able to do this. As I said, the only support that I've contemplated is initial implementation support via a loan from the State Bar General Fund. I've never contemplated that there would be funding that otherwise would go to the discipline system used to support the paraprofessional program.
So the legislature, what they do the thing we read about every year is they're approving the state bar dues, but they're not appropriating money or giving money to the state bar. Is that true?
Right, we don't receive any appropriation from the legislature or the state general fund.
Okay.
Are there other questions for Leah regarding how this works? Because I do think it's important to understand that in order to understand how one wishes to vote on this or modify it. Amos?
I just think there's a word missing, probably otherwise would be used.
Oh, I see. So it would read from funding that would otherwise be used. Is that correct?
I'm fine with that.
Okay. Julia.
Yeah, I just wanted to say I'm fine with that. And then I had one question for Leah. Do you have to submit a budget for breaking down how things are paid for with respect to discipline versus other things? So this makes sense to even be doing?
Yes, we do.
Okay, then it makes sense.
Elizabeth.
I just had a question. Is there any way where by doing this, there would come a time where there would be no funding for the implementation or maintenance of the paraprofessional program? Does that become a risk?
Well, I mean, I think when it gets to the point of actually moving towards implementation, I am going to advocate strongly, if needed, that we secure internally a loan from our general fund reserve Now, we don't use our general fund reserve to support the discipline system. That's not what it's for. So I read this as not precluding that particular possibility, but that will be, that's my only concern, Elizabeth. On an ongoing basis, this must be funded by licensing fees and be self-supported. Initially, there's going to be some startup costs. Grant money is priority number one. If not, we will have to look for a loan from this general fund.
Thanks.
And I've lost track of, do we have a first and second on this? Apparently my coffee's not working.
I move we adopt this.
Okay, and do we have a second?
I'll second that.
All right, thank you. And Carolyn?
Well, I'd like to amend it to say and/or get based on Leah's comments, no funding will come from private entities. It says for-profit corporations.
That's the next reso.
Yeah, that's the next resolution coming up.
Okay.
You're psychic.
No, definitely not.
Okay. Any other comments on this?
This is Dana. Is this in any way binding? And do we actually have the authority to be telling the State Bar how to do its money business?
No, we don't have the authority to tell anyone how to do anything. So, this is a set of proposals, and this is our recommendation to the State Bar Board. Is that correct, Leah? And I'm getting an affirmative nod.
Dana, my resolution is intended to respond to a number of public comments on this subject.
Okay. Why don't we go ahead and take a vote on this? I don't see any other hands and I don't hear anyone chiming in.
Sean? Nelson?
Brynelson, yes.
Brynelson, I apologize.
That's all right.
Falmouth? Fleischman?
Yes.
Hamilton? Judge Harper? Harston?
Yes.
Kirchmeier?
Yes.
McRae?
No.
Olvera?
Yes.
Robinson?
Yes.
Judge Rubin?
He may have had to step away for a moment, so go ahead.
Shining?
Yes. Yes.
Sarouche?
Yes.
Spyro?
Yes.
Torres Ambrose? Judge Wiley?
Yes.
Judge Yu?
And we do not have Judge Yu for the remainder of the afternoon. Okay.
10 ayes and 1 no, the motion carries.
All right, thanks very much.
Next one.
Justice Petro, before we
Yeah.
talk about this, could I ask that pages 28 and 29 of the ADL's report be shown to give some context to this?
Do we have that available?
If you click on the link, it should go there. Bottom of page 28, paragraph 13.
We're going to need to expand the zoom in, please.
Okay, so when the ADL's report came out, they discussed funding for the program. And they were talking about grants from the entities listed below. And if you could now go to the next page. So the last bullet point lists the Gates Foundation, Google.org, and the Chan Zuckerberg Initiative, which I think everyone agrees are technology-based charitable organizations. We have had for 2 years an ongoing debate about whether or not this program is a entryway for technology companies to be having access to the legal markets and to be having tech companies providing legal services. And this shows at least some people want to go to these type of organizations to get money to fund this program. So if we could go back to my resolution, my resolution is basically that we recommend as a working group not to go to these types of entities for funding for the program.
And your reason for that is? Just to be clear.
We've been having this debate for 2 years that we don't want technology companies taking over the practice of law, and this would be their entry into that area.
And so that I am clear, your concern is that allowing their charitable arms to provide funding would somehow increase the odds of technology companies taking over law practices? Or I'm trying to flesh it out.
Yeah, I mean, it's, you know, in conjunction with the Sandbox Group, yes.
Okay.
I mean, I've never viewed the two programs as being totally separate. I've always viewed that there's overlap between the two, specifically as to 5.4. And that while we've dealt with 5.4 in our program, I'm concerned this is sort of a backdoor entry into it. Now, Carolyn brought up that she doesn't want any sort of for-profit entities to be giving money for the program. I'm certainly amenable to including that, but that's my primary concern.
Carolyn?
Okay, so when I just prematurely brought this up before, I think to be specific also, there's conflict of interests here and there's privacy concerns, even preliminarily, but outside the issue of the sandbox. When people give money, and again, no offense to anyone, but in the future, Lord knows what'll happen, but data privacy concerns, if whatever is being exchanged for grants is we don't know. And so there are all kinds of things that we can't foresee when a private company, like Google.org's, Amazon, there are all kinds of these wings of companies that are being created. We don't know what they're going to want in exchange. Google just began to and just finished collecting health data from millions and millions of individuals based on Google searches. Some of these companies have power that is unimaginable with regard to what is known and not known, and that's only going to grow. So I think this is a foot in the door that we don't want to open. I don't think anybody has espoused this on this group. I think the paraprofessional concept is something that is going to help people. It's designed to help people. Having money being pulled in to the state bar that is from these entities, I don't see the point of it at all. It just can only lead to unintended consequences.
And David, are you ready to speak?
Yeah, sorry about that.
I know you're disrobing.
We've opened up in San Diego. It's a lot. So sorry about my in and out today. On this, just a judge's perspective, I understand the sentiment behind it, but if this were to come to me in litigation to interpret, I would have a hard time with it. It doesn't seem as precise, maybe as it could be, or maybe if we put a period after the word page 20 or the words page 29 of the APILS report and left, I don't know, it just seems a little.
There are other perfectly valid charitable organizations on that page that I did not want to exclude. At least my intent was not to exclude. I mean, true charitable organizations that I'm okay with.
I just don't know if we want to wander in it. To me, I'm not sure we want to. It was already sort of somewhat handled in other areas. I don't know how much we want to wander into it, especially in such a short paragraph, but that was just my observation. And now
Ira and then Leah.
How about instead of the phrase that starts with Gates Foundation, private companies and charitable organizations associated with them. I know the associated is a little vague, but that's the best I can do for now. And I agree with Carolyn about the private companies.
I could live with that.
So talk to me a little bit about, I pushed Stephen a little bit to expand on why he was uncomfortable with technology-based entities. And so I'll ask the same question so that we can have a full conversation. What is your concern about other private, what is the part of the concern about private entities providing funding for this program?
Well, I'm persuaded by the concerns expressed by a lot of other people, not in this meeting, but who are afraid that big business is going to get more and more, not that into the practice of law by way of employing or somehow associating themselves with the paraprofessionals. And all right, so what does this have to do with it? By helping to fund or shape the paraprofessional program, they could fund it and shape it in that direction. Now, big business is already in the practice of law in California, namely the gigantic law firms. But still, I think it's wise not to go any farther in that direction from the point of view of public protection.
All right, thank you, Ira. Leah, and then Brady.
Yeah, I think this is really difficult to actually effectuate given the way that philanthropy actually works. So many of those, the Gates Foundation, I know for sure, Chan Zuckerberg, they re-grant money to other philanthropies like the California Endowment, California Wellness Foundation, many of the philanthropies that you all may be very familiar with. This is the way that the world of philanthropy is working today. So does it mean you couldn't have money that was re-granted from one of these technology-based foundations? And we have Gates here. So what about Open Society Foundation, which is the repository for the Soros money, which was generated through capital and private enterprise? I just don't know where this ends, and I don't think it's realistic or easily implemented.
Brady?
So I took a look at page 29 of the ADLS report, and those are actually the only three listed there.
Right, so where it says including but not limited.
But that doesn't make any sense then, because we're saying the only things we're excluding are those that are listed, and then we say including but not limited. So unless
I'm fine limiting it to those three. Those three were listed on page 29 of the ADLS report. I like the language or other similar technology related entities. I think people can figure out what that means in context.
So that, I guess to be clear, you'd need to say, or other similar technology related entities should be after a report and before the comma, because
right,
the first clause just defines the universe, and then you're going on. But I think in response to Leah's comment, which makes a lot of sense, perhaps one way to express this would be sort of to make a recommendation about the considerations that the state bar should weigh before accepting any sort of outside funding, that the independence of the state bar be maintained, that no control should be given to these groups, something like that, rather than singling out
three companies,
organizations.
David?
Justice Patricia, this is Dave Rubin. I think what Mr. Dewar said made a lot of sense in light of what Ms. Wilson has expressed. So I think part of me, I'm trying to figure out why I'm reluctant. Something about picking on these agencies or groups in a public space like this or listing them, putting them out specifically, I'm not sure something we want to get involved with. Personally.
Ira?
Yeah, I agree with that. And maybe what it is, maybe what we're thinking of is when the legislature really has in mind some particular business, they don't name it. They say they describe it, and they say businesses in that category or something like that. They describe a category, and the category might have only one member in it. But that's what bothers me too about naming these companies.
Stephen?
Judge Rubin, the reason I listed those three entities is because those three entities are listed by name on page 29 of the
Let me
8A.
jump in on that though. Yes, they are listed. They are not listed as ones that are for sure going to be. I believe that was and Leah, you can correct me, just off the top of the head. For example, these are the kinds of companies. It doesn't mean that those would necessarily be the ones, or that would exclude other technology related companies. So there's been some concern raised by more than one person about not wanting to name individual companies. There are a couple of ways to deal with that. If you want to deal with that, you can obviously leave this as is. One is to just say, no funding will come from technology related entities, period, full stop. It's not going to be that hard to put places like Google in that category. The other would be to go along with, and I'm going to turn back to you, Brady, I see your hand up. Looking at it from a more holistic, what are the ends that you're trying to achieve, to say that when funding opportunities are being evaluated, that the following considerations be taken into account, and you can put in whatever you want to put in to that. Ira, and then Stephen, and Brady, I think, took his hand down. Oh, and Ira just took his hand down. I mean, this is not easy.
And I would ask, is Amazon a technology related company to you?
Yes.
I don't even think it's that easy. Is it? Its primary purpose isn't the delivery of technology.
One of my best friends was high up at Amazon, and Amazon.com, what everyone uses to buy stuff, is only one small part of the company. I'm not going to say small, it's a very big part, but they have all sorts of other things going on. The cloud.
To that end,
all
though,
sorts of things.
To Leah's point and to your point, right? What it really comes down to is it seems that it's not as so easy to sort these companies, and it's not so easy to know. I think if you went to most people on the street and said, what does Amazon do? Well, they sell stuff and they deliver it to you, right? And you would categorize it as a technology related company for good reason. So this is my not so subtle push to get you to think a little bit about what are the considerations that you want them to consider. What do you want them to think about when deciding what kind of funding to accept or not? If you want to put forth a resolution to help guide whoever the decision makers are in deciding how to achieve funding, I just suggest that you might be better served by putting forth what those considerations are rather than trying to categorize a company, because I think you're going to wind up with a lot of debate about what certain companies fall into or not, or is it direct funding through, directly from their charitable arms, or their charitable arm, as Leah explained, very often will fund other, large scale, but for example, public health initiatives. And now I'm officially speaking too much as chair. So we're going to go to Brady, then Carolyn, then Ira.
This one I kept pulling up and down because it seemed some people were getting it, but I think the mistake keeps getting repeated. And even when Carolyn brought this up on the last item, these aren't even companies that we're talking about. These are charitable organizations. So other similar technology related entities. Okay. Is it okay under this resolution to get them from Google directly? So I think there's still a lot of problems, even if we wanted to go down this route. And then even within the three we have there, my understanding is not perfect, but I think Google.org was created by Google, the company, and has a relationship. The Gates Foundation, my understanding, I did some work for them 20 years ago, is that it was formed with Bill and Melinda Gates' personal money, and it's not associated with the company at all. So now, a million considerations before we start, you know, specifically excluding entities or even types of entities.
Carolyn?
Okay, so two things. First, to answer Leah's comment about is Amazon a technology related company? I would point out something slightly different. Amazon actually recommends two things. Amazon actually recommends trademark services because they are so integrated with the registration of companies and buying and selling, and they do have all kinds of problems with competing products. They actually will send you to 2 or 3 low-cost trademark providers who are sponsored by Amazon already. They don't own, I don't think, but they actually have 3 or 4 trademark law firms listed on their website that they actually recommend. Maybe Leah wants to look into that. But then also on Google.org, they already sponsor some entities like this in North Carolina. So they have already funded some things, and they've funded a couple particular things. Again, maybe I think the things that Google has funded are on scholarship and different kinds of programs, but this is actually happening. So I think this really needs to be something that needs to be thought through, as opposed to, you know, we should have thought about this, we could have thought about this. I would just say profit-oriented companies or private corporations. You know, and leave the, you know, this is the kind of thing that I hope the State Bar reports in its annual report. I think there is a slice in the pie there for things like this. I don't know that they list out particular organizations that give funding. Maybe we add on here that any philanthropic grants to support the paraprofessional program need to be identified in its budget or reports.
I think that's a great recommendation, Carolyn. Just full transparency on all funding sources.
Ira?
I think it should, this resolution should say no for-profit companies. That's the opposite of nonprofit.
But isn't it, but the Gates Foundation is not a for-profit company.
I know, I don't know any way to solve that problem, but the idea that it shouldn't be funded by for-profit companies, I think is a good one, and it should be in here.
Okay, can we hear from Julia, please?
I agree with the suggestion that we talk about the transparency instead of naming names. I think since the State Bar, if I'm correct, Leah, tell me if I'm incorrect, will be the one to decide what sources are used. Is that correct, Leah?
The State Bar will decide what sources of funding are used.
Yes.
Yes.
So can we just formulate this in a way to say that whatever we resolve is that the funding for implementation or maintenance of the paraprofessional program will come from sources, you know, and we'll describe some of the sources that we want, not versus technology. I think that technology related gets us really in a stuck, and just say that the proposals be sent out, or I don't know, at least they're transparent in the budget reports. But I think at the end, we've got to have some trust in the State Bar to be able to figure this out, since they're the ones that's going to be responsible for maintaining this program and be you know, supervising the licenses as well as the exams. I just don't think it would be appropriate for us to strap Leah and or the rest of the State Bar who's going to be responsible for this. I would have some faith in them to, you know, choose wisely, but I do think the point of transparency is important.
Thank you. Elizabeth?
I'm just trying to wrap my head around everything. And I guess the goal is to make sure that the program takes off, implementation and maintenance. The goal is to get it to take off. And eventually the program is going to be self-sustaining through licensing fees and things like that. And please correct me if I'm wrong. But that's the goal. And then we've heard public comments from a lot of commenters saying that, using the discipline fund money is detracting from, to be used to the paraprofessional program is going to detract the state bar's goal of disciplining attorneys that there's already a backlog of. I'm just trying to understand it. And so I think one way to deal with it is, obviously we want this program to take off, and we don't want to say no to certain funds that will help provide access to justice to a lot of people. When someone wants to give money, they have the money. But I think what I heard coming in from these discussions is, but let's put some specific terms and say, yes, we will accept this money from these sources. However, these sources will not have any control or say on how essentially the
money's used.
Sorry, yeah.
Were you saying basically no control or say over how the money is actually used?
How it's used, or yeah, that's what I'm thinking. So it's like you guys were saying, what I heard, maybe it wasn't said out loud, but set parameters as to how that money will be used. I think that would be a good solution. Thank you.
Thank you, Elizabeth. Stephen?
Yeah, Leah, perhaps you could tell us how those entities came to be listed on page 29 of the ADL's report. What was the motivation behind specifying them?
Well, I just want to clarify, they weren't specified for exclusion. They were, these types of companies might be pursued. For funding. I'm not exactly sure. I wasn't the original author of that report. I know that Chan Zuckerberg has done some work in the legal services space writ large. So in terms of thinking about philanthropies that might be approached to fund, certainly thinking through those that have funded broadly in the legal services realm, that would be a first group that we would go to. I'm not sure how Gates or Google.org got in there. The principal authors must have thought or understood that they may be interested in supporting this type of initiative. So,
but we don't know.
No.
Okay, Brady.
One other way to go about this, there, as an alternative to, or in addition to what Ms. Olvera said about, making crystal clear that, no control or decision-making authority should be given to funders, or my earlier suggestion about conflicts of interest or, things of that nature, would be to resolve that the State Bar shall not accept funding from organizations that aim through their funding of the program to profit from the program. And I know that, we're allowed to be in these policy recommendations a little bit vague, but that at least puts us on record as saying, hey, we're not going to be dealing with organizations who, in funding us, have some profit motive for doing so. And then couple that also with the public disclosure recommendation.
Thanks for that thought as well. Other comments or thoughts before I turn back to Stephen to ask if he would like to modify this resolution in any way? Not hearing or seeing anyone. Stephen, where are we?
Why don't we say, well,
oh, Carolyn, sorry, I'm sorry. Carolyn just raised her hand.
I just want to add, I like Brady's wording, and we'll just ask Steve if he likes it.
I would just try to simplify it. Will come from technology related entities. I would say including those listed on page 29 of the ATO's report, period. There shall also be.
Hold on, let Louisa do this.
Okay. Period, after ATO's report. The State Bar shall also provide full disclosure of all funding entities. And I think you need to delete the word "the" before technology.
Ask Leah a question. Are you obligated at this juncture to disclose funding entities?
No.
So Stephen, would you like any further modifications to this resolution as it currently reads?
No, I'm fine with that.
Okay, and is there a second to this? I'm not hearing a second. I'll ask that question again once Brady has a chance to say whatever he wishes to say.
So I was just to make clear, my concern with this is, again, we're still singling out some organizations which are nominally charitable organizations, and one could imagine them making a no strings attached gift that, considering all the circumstances, might be appropriate to accept. So as an alternative to that, we could focus on, shall not be funded by organizations where the gift is conditioned or, has a profit aim. That would be an alternative suggestion.
Thank you. Understood, Brady. So I'm going to ask the question only one more time. Is there a second to the motion that's currently, the proposed resolution that's currently on the screen?
I will second.
Okay, was that Carolyn?
Yeah.
Okay. Any other comment before a vote? To go ahead and take the vote, Louisa.
I have a comment.
Oh, go ahead, Ira.
I think practically any company is technology related.
We've had this conversation that this is a term that is potentially vague, and we have a motion and we have a second, so we do need to take a vote on it. Okay, Louisa?
Bashan? Green Nelson?
No.
Thelmett? Fleischman?
Yes.
Hamilton? Judge Harper? Hartston?
No.
Kirchmeier?
No.
McRae?
No.
Olvera?
No.
Robinson?
Dane?
Judge Rubin?
No.
Shining? I'm sorry,
Carolyn,
Shining?
you're muted, Carolyn.
Yes.
Sarosh?
No.
Spyro?
No.
Torres and Breeze? Judge Wiley?
No.
Judge Yu? We have 2 ayes, 10 noes. The motion fails.
Ira, would you like to say something?
Yeah, how about, I would move to, that we adopt something like the second half of that motion, the disclosure part.
Can we please put that back up on the screen so I know what we're talking about? Okay, so Ira, if I'm hearing you correctly, you correct me, okay? That you would like it to say resolved that the state bar shall provide full disclosure of all entities funding the paraprofessional program or something like that?
Yeah, public disclosure. Yes, I would. That's what I'd say.
Okay. So resolved that.
Keep that, Louisa. Yeah.
The state bar shall also provide full public disclosure of all entities funding the paraprofessional program.
Should we take out the word also?
Yeah, we'll get there. And then if you could please remove also. And then Ira, take a moment to read it and make sure it's what you want.
Shall yearly provide. How's that?
I'm sorry, that was yearly?
Or annually?
Annually.
Yeah. Yeah, okay, yeah, I move that.
I'll second the motion.
Thank you. Anyone wish to make comment, have questions, discussion, thoughts on this? Carolyn?
I'm in favor.
Anyone else? All right, I think, Louisa, we can go ahead and take a vote.
Bashan, Nelson,
Yes.
Belmont, Fleischman,
Yes.
Hamilton, Judge Harper, Artston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin,
Had to step away momentarily.
Shining,
Yes.
Sarush,
Yes.
Spyro,
Yes.
Torres and Breeze, Judge Wiley,
Yeah, and Judge Wiley had to step away. The trial courts are hopping, I'll just say that.
okay, and Judge Yu is absent. 10 ayes, 0 noes, the motion carries.
Okay, thank you. And I believe that puts us back, Leah, into, you had an additional staff proposal, is that correct?
We have an additional agenda item, which, Louisa, if you could put up that resolution, that's to approve the language that will be used to describe the public comments. This was sent out to all of you in March. I don't believe that Linda received any comments from any of you, since I know now that she's listening anonymously in the attendee pool. She can raise her hand if somebody did provide any comments. I know, Stephen, you had a follow-up request to send information, which I believe did happen. But that's my hope, that we're going to be able to get approval for this language. So if you could.
This is the first I'm seeing of this language. Let me see it.
It's this, it was attached to the agenda item. It's the same thing that was sent out to you in March.
Can we see it? Pull it up.
Yes, give me one moment.
Sorry, Louise, your time.
I'm sorry, I'm just looking for it. It's on the agenda item.
Item F.
Yes. Okay.
So if you could scroll to the attachment. So the only change is this, if you keep scrolling down. The revised recommendations based on public comment review. But essentially, that's the placeholder for everything that you just decided. So all of those resolutions would go there.
Okay.
Yeah, Leah, I'm not in favor of this. If I wasn't clear last time, I'll be more clear. I can live with the top level numbers, but the whole way the program was put together with three different questionnaires asking three different questions, combining them all, and then trying to identify where people go into what category and creating new issues that weren't identified in the questionnaire. I'm just not okay with any of this.
Okay. So it sounds like you won't be voting in support. My powers of inference tell me that you're not going to vote in support, but I don't know what else to say. I know I understand that issue that you've had and you have raised.
All right, so let me go back and explain where I'm coming from. The State Bar put out 3 different public comment forums at 3 different periods of time, which were overlapping for at least some period of time. None of them asked the person filling out the questionnaire to self-identify whether they are an attorney, a paralegal, an academic, a consumer, or anything. Although one of the 3 questionnaires was geared plainly for consumers, but I'm not really sure what consumer means in that context because I'm an attorney and I'm a consumer. All 3 sets ask different questions, except possibly the one common question was, are you in favor, are you opposed, or are you in favor if changes were made? I had extensive email exchanges with Linda Katz and Leah and Justice Petro, where I thought I asked for those materials to be sent to the whole working group, and they weren't, because I thought we were sort of dropping this Power BI presentation. I mean, this just is not statistically meaningful the way this was all put together. Most of what the State Bar has done is tried to match email addresses with email addresses on record with the State Bar, which is fine only so far as that goes, but someone could be an attorney and could have used their private email address for the form, or someone could be an attorney for another license in another state providing comment. And just none of this works. I mean, none of this would get, in my opinion, would be admissible in a court under Sargon. I mean, this is just not the way it should have been done. If it was important to identify the responding parties based on whether they're an attorney, an academic, a paralegal, or whatever, then the questionnaire should have been set up on the front end to ask that question, to have them self-identify, and then maybe this could have been done. But even then you have the problem of 3 different sets of questions being asked and all put together. And so to avoid all of this, I said last time I could live with the top level number that we received 1,200 comments and 900 were opposed to it and 200 were in favor, and whatever the number was for the 3rd group. But this is not well done. This is not something I would put my name on. That's how I feel.
Okay, so just to clarify, if you can please scroll up, Louisa. This has been changed based on your feedback. No, can you scroll up? Okay, to the beginning. So we're just talking about public comments received, and the categories are attorneys and non-attorneys. That's it. There's no more consumer. There's an explanation of attorneys were identified through looking at the State Bar and the other 49 State Bar websites. You're right, if they used a totally different email address, we wouldn't know that. So we did take out all of the language about consumers based on your concern. There are many fewer categories here based on the concerns you identified. And then if you scroll down further, Louisa, you also had objected to the way that organizations, to the next page, that organizations were handled. So this was, your concerns were addressed here as well. So I guess I just want to clarify that this was changed in response to your concerns.
Absolutely, it went through changes. But, you know, academics, some of my partners are full-time practicing attorneys and they teach law school. Which category do they fall into? Consumer advocacy. Carolyn and Ira are consumer attorneys. They represent consumers. Are they characterized as lawyers? Are they characterized as consumer advocates?
Yes,
Government.
No this is only if we received a letter from an organization. That's this whole breakdown here is just an organization. So the organization itself, if you look on the website about what the organization, the name of the organization,
Okay,
it says,
wait, both stop. I want to make sure we're understanding things. Leah, on this chart where it says overall position organizations, are you saying that this chart solely reflects the position of self-identified organizations, not, for example, an attorney at a law firm who sent in a letter, an individual letter as an individual.
Yeah, this isn't, we didn't, originally, we attempted to break down individual commenters into all of these categories. And based on the objections received, we stopped doing that. So now it is just the organizations were categorized in this fashion. The individual commenter is an attorney or a non-attorney, that's it.
And we eliminated the categories like consumer.
For the individual commenters.
Okay, so just so I'm going to say it again to make sure we're all on the same page. The individual comments are attorney, not attorney, based on searching the 50 state bar websites. And the organization chart is organizations only. Correct?
Yes.
Okay, and I cut both of you off because I wanted to make sure I understood that. So Stephen, you were in the middle of saying something.
Yeah, why don't you click on the Power BI link? Okay, why don't you hit the drop down for topic? Scroll down, please. Maybe, okay, none of these categories were self-identified on any forms. These are, as I understand it, State Bar interpreting the form, interpreting the public comment and putting it into a form. Could you pull down topic, subtopic? Scroll down, please. Yeah, trade protectionism was one that jumped out at me. None of these questionnaires had any question about trade protectionism.
I want to be fair to the State Bar folks who went through this, and Leah can jump in as always. Anyone should correct me when I'm incorrect. We made the request as to have them categorize things, including going above and beyond what the question asked. So for example, if a question asked something, but an answer went further, or it was a catch-all, general comments about things, we didn't want to lose people's commentary and therefore had those categorized as well. I don't think there's any question, Stephen, that there was not a category where we said, tell us your, here's the category, personal story. Here's the category, trade protectionism. But people made comments that fit within those, and we were trying to get our arms around over 2,000 comments in such a way that we could give all of them, a fair consideration and not lose things. And so, I mean, I'm not saying that anything you're saying is wrong, but I also don't want to give the impression, because I think it would be wildly inaccurate, that the State Bar was like willy-nilly trying to make things up.
I'm not trying to suggest otherwise.
I have a suggestion. If you object to the categorization of the topics, which was done by staff, right, to organize the comments, as Justice Petru said, perhaps you either want to strike reference to the Power BI altogether, because that level of detail is not reflected in the document you're being asked to approve. You could strike reference to Power BI. You could simply say, we could strike out transparency and ease of review and just say all comments and letters were updated to the platform. We could annotate that or add a sentence that says the working group does not, a disclaimer, so to speak, on the way that the topics are categorized in Power BI. The working group doesn't agree with that. These are all suggestions I have, because none of this level of detail is actually reflected in what you're being asked to approve.
So Justice Petro, look, no one is disputing the State Bar staff spent a tremendous amount of time doing this, but John Wooden said never mistake activity for accomplishment.
So what about Leah's suggestion that we not include any of this?
Well, okay, so let's go back. So let's get rid of the reference to the Power BI. Let's go back.
Let's give Louisa a moment here.
Maybe Louisa, can you turn on just Adobe Edit functionality?
Give me 1 second.
Take your time.
Let me just download this. Okay, are you able to see my screen?
Yes, we are. Thank you. So I believe we wanted to go where we were before, and I don't know if you're able to make it a little bit bigger so we can see better.
Sure.
Okay, so let's go to where it had that link that we just clicked. And you can just delete that entire sentence, all comments and letters. Stephen, would you like us to go back to the beginning of this and kind of look at it carefully, paragraph by paragraph?
Yes, please.
No, just
No, to that section. Yeah. Okay, here we go. Attachment A. So let's take a look at the first paragraph. Carolyn, would you like to chime in? I'm sorry, you're muted.
Okay, I generally and almost completely agree with everything that Stephen is saying, and I don't want to go into all the details of that. But do we really, is there any other way we can make a link to all the comments? The raw data, the data.
Raw data.
The just PDFs, all the comments. It's one, there is a folder.
Leah, let me ask a basic question. And if I missed it, I apologize. If the identity of the public commenter was important to what we're doing, why wasn't there a box on all the public comment forums? I am an attorney, I am a paralegal, I am a consumer, I am whatever. Why are we trying to now extrapolate instead of, if that was important, it should have been done on the front end?
I don't disagree with you, but you keep talking about the consumer, the this and the that. Right now, it's just attorney and non-attorney. That's the only distinction that's being made. I think, point well taken for future iterations of public comment.
Yeah, and I don't know that it behooves us to continue this part of the conversation about why was something not done. Leah just said, live and learn. I think it would be done differently. We're doing the best we can with the information that we had. And I don't say live and learn in a dismissive way, because I think there was a lot of effort put into this. But this, this attachment A was circulated on March 24th. And I'm going to take the time right now, because it is important to take a close look at this. But why don't we focus on it? Other people have general comments. They're welcome to make them. If other people have things that they want to strike or add as we go through this, obviously speak up. So let's just do one paragraph at a time, if you don't mind, so that we're not jumping back and forth as little as possible.
Third line, were characterized, I suggest.
I'm sorry, I just want to make sure that I find it. Okay, so 71% of individual commenters. Is that where you are, Stephen?
Yes.
Okay.
After the word characterized, I would add by State Bar staff.
That's fine. Go ahead and add that in, please.
Categorized as attorneys by State Bar staff.
I apologize.
After the word attorneys, can you add by State Bar staff? I'm sorry, because you're gonna have the same thing with the things after each semicolon. I suggest that at the very beginning of this sentence, you, Louisa, can you go to the beginning of this sentence, please? and put at the beginning of the sentence where it says 71.
Oh, got it.
Okay, that same sentence.
Okay.
So at the beginning of that sentence, can you please say state bar staff categorized (71% of individual commenters as attorneys. And I think that way it's clear that they also categorize the non-attorneys, et cetera.
Justice Petro, I would like to delete the last two sentences of that paragraph.
Okay, give me 1 second.
And delete the last two.
Wait, don't delete anything until I actually tell you to, okay?
Got it.
There's the request, but before deleting this, I'd like to understand, is there some way that we can keep a separate document? What I don't want to have happen is that someone suggests we delete 2 sentences and then there's a group discussion that results in our putting them back in and all of a sudden you have to type up 2 long sentences. This is what I would like to avoid.
She's not deleting it. She's just going to make a note, or it would be a strike through. It's not difficult with this Adobe.
Okay. Is there any discussion in regards to paragraph 1? Any discussion regarding making it clear that the state bar staff is the one who categorized as attorney, non-attorney? And any discussion regarding removing the last 2 sentences or comment about it?
Well, I agree with removing the last 2 sentences. And the other change.
Anyone else? Okay, then let's keep moving down to the next paragraph.
So these 2 sentences are strike through, correct?
Yeah.
In light of that, I don't believe we need that graph that follows.
May I say something? I misread which are the last 2 sentences.
Well, he said the last 2 sentences of that paragraph.
I understand. I misread it. I would propose striking the sentence before that too.
I agree.
So starting with 71%.
Yeah.
So is the point, can I get to the point, which is the point that you don't want this document to include any indication of or any categorization of how many were in support or not?
Yeah. Well, the main point is that when it does that, what it's really reflecting is the attorney's opinions, because they were such a big percentage of the individual commenters.
Well, I'm sorry, I didn't understand.
In other words, 71% of individuals indicated opposition. But look at that 71%. It's way largely it's lawyers. Unless I'm misunderstanding. I mean,
right, which is why it doesn't make sense. Either you remove all the sentences or none, right? Because as you indicated, 71% of individuals as a total, but when you look at the attorney, it's attorneys opposed at 90%. Not, yeah, and the numbers are quite different.
Yeah, well, because if you don't read it carefully, it's misleading. Right. Some 71%. Oh my God, a terrible program. You know?
I appreciate you lifting up the higher level question, Justice Patru, because I think that's the question for the group. These edits are going to consistently remove any reference to the analysis of position. If I'm speculating on where Stephen is going. So it's really a question for the group. Do you want your summary of public comments to just simply be numbers received?
Yeah, that is the question. And that is the question I'd like to raise before we keep going through this, because either the group essentially wants, you know, some level of analysis, which is what's in here now, with potentially minor modifications or significant modifications, like removing the link that we just removed, or the group doesn't think there should be any categorization, in which case the, you know, mandate could be to you to revise this document to remove any such references. I think it's a significant question. I think there should be discussion about it. And before I open up the table, I'm going to start with Julia. Once I do that, I'd like to hear from you, Leah, about what is the point behind categorizing and what was the purpose of preparing this document and how would it be used?
This is a very standard process for analyzing and presenting public comment, the percent opposed or in support. The point is to give the decision-making body, at a minimum, if not other stakeholders, an overview of the positions taken during public comment. Increasingly, you will see the bar break things down by attorneys and non-attorneys as we work to accurately demonstrate ourselves to be a public protection, public serving organization. So while this particular breakout is not something you would always see in our public comment analyses, certainly you see support and oppose. So I do think this is kind of the bare minimum of what would be expected in terms of a public comment analysis.
Julia.
So for me, I find it very helpful to keep the designation of attorneys or non-attorneys. I think it says a lot about the group of people that are opposing this. And I think if the emails were easy enough to cross-check, I don't see why that is a misleading or inaccurate graph. And I think it's a lot easier to understand than reading a lengthy report. I think it's very helpful. And I think it just says a lot of who is responsible primarily for opposing this. And so I would like to keep the graph. I don't mind removing the last two sentences, but I think it's important to know who really has this position, and it's our colleagues as attorneys. That's my 2 cents.
Could I hear from someone else? Anyone else wish to be heard? Because if not, I think we need to figure out a way to take the temperature of the room, for lack of a better term, and understand whether collectively the group wishes to strip out all categorization as, you know, in support of, not supportive, or not, because otherwise this could be a futile exercise of going through this paragraph by paragraph. Anyone, Leah, Greg, suggestions about how we go about doing that?
Well, you might want to go around the room, the Zoom room, just ask each member the policy question.
Okay, well, let's do that. Let me go to the top of my screen. Stephen, I think we know what your position is on this.
Correct.
Okay.
I just wanted to respond to Julia briefly, if I could.
Go ahead.
Julia, I'd be all in favor of what you were saying if I had confidence in the data. I don't have confidence in the data. While cross-referencing with the State Bar website or database of emails may properly include some people as attorneys, it's not comprehensive if people didn't use the same email address that they have with the State Bar. I have a work email, I have a personal email, and then I have one for junk. And, you know, if I was a member of the public filling this out, I probably would have used the junk email address, which the State Bar wouldn't have.
Okay, Kimberly.
I understand that Mr. Fleischman's concerns, but I also think this information is really important for individuals to understand. So I'm wondering if we could put some kind of footnote in there that this was, you know, derived from staff's review of the information and what was presented. That way we kind of have both the concerns addressed as well as making sure we get this information out there.
Including the footnote, for example, could concern that attorneys were identified by comparing the email addresses. Is that fair, Leah?
I believe that's already in there. Maybe Kelsey, you can comment on that. I've seen that methodology written somewhere.
Yes, we do have a footnote in this attachment that explains the process.
Can we please see it?
It's identified.
Okay, I see it's footnote 3. Individuals were identified as attorneys through a search in the state bar or other states' records. A number of commenters did not provide enough information, no full name or email address. Well, this doesn't address Stephen's concern about an attorney using an email address that isn't their address that's linked to the state bar. So I do think this would have to be modified a bit, saying individuals were identified as attorneys based on, when you say based on their written comments, what does that mean? Does that mean?
I'm an attorney and I've been practicing for 40 years.
Okay, so this sentence is a little bit confusing, the way it's currently written. So if I'm understanding you, Leah, correctly, it would be individuals were identified as attorneys based either on their written comments self-identifying or through a search in the state bar or other states' records for their email address provided, something like that.
Yeah.
Mrs. Petro, if that's where we're going, I'd like to add.
I don't know that's where we're going. I would like to actually ask everyone so that we can get a sense for where people are. And Carolyn, did you have comments you wanted to make before I did that?
Yeah, just I echo Steve's problems with the data, you know, but he's made those points really well. I would add that just focusing on the fact that the state bar internally, without our permission or this committee's understanding or knowledge, went and searched attorney records that it has and that only it has for attorney identification is disturbing. And
hold
on.
Carolyn, that's not correct.
Okay. I understand that, but this footnote says.
I agree with you. This footnote needs to be revised. It's not clear. And I do think, Leah, that it's very important that when you're putting in here, you know, the state bar or other state records, what is it that we're talking about?
Okay. Well, also that we had, when it says state bar, that could be impugned, that could be implied to be us. We are all a state bar committee. So our people in the general public may not know that we're not quote unquote staffers. I think it needs to be just other than saying state bar staffers, because I'm not, this was done without our imprimatur. Nobody said, hey, do you mind, committee? We're going to go do this. Then we take the information that's from 3 different surveys and we pluck out very carefully this information. And 3, there have been comments made that, attorneys are not, there have been very serious comments that are made here that many of, about this, the attorneys.
Right. So I'm going to ask you to, I'm going to ask you to hold, and Julia as well, unless she has something to say about the percentages in here. What I would like to understand at this juncture, because it will help us inform how do we need to modify the document. And then Carolyn, your comments or Stephen's or anyone else's about particular things are more than welcome. But
can I ask one question? Isn't all this information in the public domain? Anyone can look up these emails addresses on the State Bar website?
Yeah.
Yes, but the problem is that the footnote is not clear that that is what information.
So I've asked staff to draft a revised footnote that we could consider. So if we can just give some time for Kelsey to work on that, and then we can put it up in a moment.
Right. And so that's the issue. The issue with that footnote is simply it's not clear and it needs to be clarified, period. And then we'll get back to it. The issue on the table, so that we know how we're going through this document and what kind of modifications potentially we want to make, is whether people want to include that, kind of baseline information about opposition and support. Stephen has said clearly and repeatedly what his concerns are about this. Leah has made it clear kind of that this is the, minimum that would be expected on review. I would like to know where people are so that if it's clear enough one way or the other, we can move forward with going through this document informed by that. So we know Stephen's vote. I'm just going to go through who's on my screen here. So hold on. Carolyn, where are you on this?
I'm in full agreement with Stephen and then more so.
Gotcha. Okay. And then Julia.
I'm in favor of what is in there.
Okay. And when I say in favor, I understand people may have minor modifications to this or that. We're just getting the baseline here. Okay, let me go. Elizabeth?
I'm in favor of what's there. A lot of work has been done, and I think that's good enough. Thank you.
Okay, Ira?
I'm against support in gross. In other words, a total of all individuals supported, X% supported, X% didn't. A total of all organizations supported, X% didn't. I'm against that. I am very much for saying, by category, for instance,
Attorney, non-attorney.
X% of attorneys, non-attorneys, X% of attorneys supported and did support, X% of non-attorneys, also on the organizations, X% of attorney membership organizations, legal service programs supported, X% of the other type of organizations supported.
I gotcha. Okay. Let's see here. Nicole?
I'm in favor of what's in and amending the footnote.
Thank you, Nicole. Kimberly?
Same as Nicole. In favor, just change the footnote.
Okay, Amos?
I agree, including what's there, amending the footnote. I would also support an additional footnote raising people's concerns.
Okay. Fariba?
I agree with what's there, changing the footnotes, and I agree with Ira's comments, because when you categorize the positions like that, then giving a combined number is really not determinative. So I would also want to delete that type of category.
Right, I understand that position. Okay. Amos. Oh no, we did Amos. Okay. Julia. Julia, can't hear you.
I already said in favor.
Okay, thank you. This is the problem with my being able to see 3 people at a time. Monica?
I'm in favor of what's written with this slight modification of the footnote.
All right. Dana?
I agree with Judge Wiley.
Okay. And did I miss anyone? Carolyn, we got, okay, if you're a voting member of the working group and I didn't call on you, I apologize and pipe up. Okay, so it's pretty overwhelmingly one way. There are 2 people who want to eliminate all the, percentages opposed for. There are 1, 2, 3, 4, 5, 6, 7, 8 people who want to include the information with the modification to the footnote, and potentially at least 1 person raised adding an additional note about the concerns raised by Stephen and Carolyn. And then there are 2 people who wanted essentially as is with the changes to the footnote, but would like to remove the categorization, the grouping of, for example, attorney, non-attorney, all individuals would want to remove the grouping of all individuals. So I think, that is our kind of mandate or group decision about how to move forward collectively. With that, if we're ready to go back to the document, or Stephen, your hand's up.
If that's how we're going forward, I have comments on the footnote.
Okay, well, the staff is working on a proposed footnote right now, so we're gonna.
I just emailed it to you, Louisa. I just received it, and it's so you can share a proposed revision to footnote 3 if you check your email.
So let's wait for that. So Stephen, if we can wait for that so we can look at it and see what you think of it.
Sure.
So obviously there's some typos in here. Let's fix the attorneys at the very end where there's the bracket. And on number 1, let's put a, yeah. I have a question. What does licensee records, a search of licensee records on the state mean?
That's a section on our website. That's licensee records. I don't.
Well, can we put on the state bar's website? Because it's just confusing the way it's written. And is that on the public website?
Yes, through a search, we can just strike of licensee records. Yeah, it's on the public website. It's on the home page.
So a search on the state bar's public website or other state bars' public websites. Is that accurate? Leah, before I ask others, are you okay with that language? Because I want to make sure it accurately, that it's accurate.
Yes.
Okay, now, Stephen, once you've had a chance to actually read this.
I'd like to add some prefatory language.
And what would that be?
Something along these lines. The State Bar used 3 different forms for public comment, asking 3 different sets of questions, period. None of the forms asked the responding party to self-identify as an attorney, non-attorney, or otherwise, period. Therefore, individuals were identified, blah, blah, blah. To give some context.
I understand. Yeah. Is there anyone who wants to comment on that request? Anyone vociferously opposed to it?
So Stephen, then you don't think you need another footnote if this addresses the concern about the surveys, right?
Yeah, whether it's in a separate footnote or at the beginning of this footnote, it needs to be somewhere before this language to explain why we are where we are.
Okay, I'm in agreement.
Okay, so Stephen, I would ask you please to quite slowly, since Louisa is trying to do 4 things at once, including typing this up.
Public comments were sought using 3 different questionnaires which asked 3 different sets of questions. Period. None of the questionnaires asked the responding party to self-identify as an attorney, comma, consumer.
But again,
or
we're not,
otherwise.
but understand we're not putting any consumer information in this summary.
Okay, as an attorney or otherwise.
Period. Yeah, and then do a therefore, comma.
Therefore, individuals were identified by State Bar staff
Okay, that makes sense. Carolyn?
Okay.
Okay, and just to, if anybody is kind of thinking that this is not important, I would just say the NORC study that the Justice Gap did, that was done by the State Bar for the Justice Gap, was an actual survey that had, had error limits. It had, you could go and look at the State Bar website. They'd give you spreadsheets. All that data was there, whether it was complicated or not. But if it was a very And you could argue about the questions and all that kind of stuff, but it was one study. It was done to a particular statistical standard. It would probably meet the criteria that Steve mentioned under the, the laws of evidence. I don't know, he and I could debate that, but but this is different. This is very different. And so to the extent that we're relying on this survey to, to tell people where it came from and not have them do FOIA requests all over everywhere, to get data. I think this is very good, simple clarification that says this is not the NORC study that the Justice Gap, that our Paraprofessional group has been asked to follow and discuss and talk about. This is different. This is a different compilation of things that do not have any. It's just okay. I'm losing my point.
Just to clarify, like public comment and summarizing response to public comment is not equivalent to a research evaluation. It's not designed to be. The concept of statistically significant is, I've never seen it applied in public comment analysis. So
I agree, Leah, but we're now trying to turn it into that through this
well, we
chart.
can, we can debate, and I'm sure Leah would disagree that we're trying to turn it into that. I think honestly, that's pointless debate about whether we're trying to turn it into something. There can be, what matters here is that there be clarity. And I think that, Stephen, your suggestion about clarifying the fact that people were not asked to self-identify as attorneys and that question wasn't asked on the form is important for people to understand. And it also explains why on earth are state bar staff going through and trying to figure out who's an attorney. Other than this would be the new footnote 3. And the deletion, so what's difficult at this point is, of course, we have different documents up. Is there any way to change that summary, Leah, so that this is now looks like the new footnote 3?
Yeah, Louisa, I think you can go back to the PDF, stop screen sharing, strike through the existing footnote through, then copy that text and pop it in there.
And I also would like that modified document to no longer have that link that was removed.
It's stricken.
Okay, and also there was another change to that first paragraph.
Yeah, I'm not sure if she's going to be able to insert the text. Let's see.
Okay, so
okay, great.
Footnote 3 has been struck out and this new one has been highlighted.
Thank you.
And can you show the other changes, Louisa, if you scroll up? This one is probably still in the comment bubble that it needs to be added. I don't know if you can cut and paste that from the comment bubble and stick it into the document. No. Yeah.
Let's do that.
Leah, while she's doing that, is there any way you could email me this document so I can look at it, since I can't look at it on the screen?
This is the same one that was sent out on March 24th, other than the edits that we're making today.
March 24, got it. Thank you.
Posted to the agenda.
And it was posted to the agenda as well.
Oh, 2.
So that's 71%. That starts with the word 71. You gotta strike that now.
Yeah.
No, yeah,
No,
go too
just
far.
up to attorneys. Yeah.
Right.
Yeah. And when we find,
Leah, let me interject for a second when Louisa's ready.
Is that helpful?
Yeah, can you remove, yeah, that strikeout needs to be removed from those ending sentences.
the strikeout that begins with recommendations with modifications. towards the end of the paragraph.
Yes. One second, I have to do this a different way.
Okay, great. And there's no way to just remove that 71, the thing you have highlighted, we can't just remove?
Yes, we can. So I'm gonna remove this.
No, I don't think we're one.
No, no,
Oh,
do
we
not
don't.
remove that. Just remove what you have highlighted. Okay. Okay, that's fine. So this is what we've discussed so far. We have the modifications to that first paragraph. We've removed the link and we have changed footnote 3. Let me go back to a high level question. Because again, this informs any further modifications. We had Ira and someone else, I'm sorry, I can't recall right now who it was, advocating for example, the position by sector individuals, removing, no, actually, I'm sorry, not there. Removing the sentence in the first paragraph that reads 71% of individuals indicated opposition, 24 support, additional 4, to remove that sentence in its entirety, because Ira's position, as I recall it, was that he just wanted the pro-con broken down by attorney, non-attorney, and not aggregated, especially since the number of attorneys eclipse the number of non-attorneys and therefore gives a perhaps inaccurate representation of position. Ira, is that a fair summary?
Yeah, that's quite correct. Yeah.
Okay.
I was the other person. I just don't
Thank
think
you,
a
Fariba.
total, a total number considering the individual numbers is determinative at all.
Okay, so the proposal from Ira and Fariba would be to remove that sentence regarding 71% of individuals indicate opposition, et cetera. Similarly, can we please go down to the next bar graph?
No.
Okay, this is broken out. Let's move up a little bit. Okay, stop there, stop there. So Ira, am I also correct that here you don't want it to say 74% of organizations indicated opposition? Or are you okay with this one here since it
No, I would like to remove that sentence too.
Okay, and also would you want to remove the following sentences that says the majority of the opposition reflects the position, et cetera?
No.
Okay. So you would just want to remove the 74% of which indicated opposition?
Yeah, the aggregation without breaking down who it was that opposed. Yeah.
Okay, so the next sentence would just be modified to say the majority of opposition rather than this.
Yeah.
Okay, so understanding that the request on the table by Ira and Fariba is to remove the percentages of individuals all put together that are pro and con, and to remove the percentage of organization position that is con. I'd like to poll the room to understand where people are and see how we're going to move forward on that front. And Stephen, since you're the first person on my screen, I'm going to start with you.
I'm going to abstain on that one.
Okay. And then let me scroll down here. Ira, obviously, I think I know where you are on this. And Fariba, I know where you are. Carolyn?
Abstain, same.
Okay. And then my screen just freaked out on me. Nicole?
I'm fine with the way it is.
Okay. Dana?
I would prefer to keep it as the staff wrote it.
Okay. Monica?
I'm fine with the additions that have been discussed.
Well, no, so the question on the table is as is, or do we want to remove, so I'm seeing as is, okay.
Yes.
Thank you. Carolyn?
I'm sorry, I was distracted there for a moment, to be truthful.
Okay, so I'm gonna ask the question again. Ira and Fariba's position is that we remove the information about individuals as a whole, where it says individuals, X percentage of individuals as a whole are opposed or for, and just leave it at the attorney, non-attorney, for the reasons that Ira has explained before. And likewise, they would like to remove the 74% of organizations language and just leave it by the kind of organization. So do you agree with Fariba, Ira? Disagree? Abstain?
I don't think it makes a difference, so I'm going to abstain.
Okay. Nicole, Dana.
Or just oppose, I guess.
Kim, Nicole, I think Amos.
Yeah, Ira, my screen keeps changing on me. Julia?
I'm fine with the changes we've made in keeping the graphs.
Okay, so Amos?
As is, as well.
Okay, and then Kimberly?
As is, I think there's enough other information that it explains it, so I think it's okay.
And Elizabeth?
As is fine.
Okay, so if you're a voting member of the working group and I haven't called on you, my apologies, please pipe up. All right, so that was a very strong on the side of leaving it as is and not making those additional changes. So with the changes that we do have, the new footnote 3 and the change in the, can we go back to the beginning, please? Okay, and the changes that have been made there. Does anyone else want to suggest any other individual change or kind of or category of change?
I have a question about how State Bar came to the 106 number for organizations. As I recall, there was one letter submitted on behalf of 2 or 3 dozen legal aid organizations. Was that counted as one or the total number of organizations?
No, I believe that pursuant to your feedback and back and forth with Linda, that was counted as one organization, but each of the individuals that submitted, if multiple organizations signed on to the same letter, each of those organizations was counted. As one organization, if multiple people from one organization submitted a letter, those multiple people were counted in the individuals and it was one organization letter.
Thank you.
Okay, does anyone have any other edits that they would like to propose?
Can I see the next page? Because Your Honor, what I got on March 24th cuts off after the second.
Okay, and yes, we can go to the next page, but also it should also be attached to the agenda from today, but let's go to the next page. And you tell us here, pause here until Stephen says to go down.
You can go down.
Yeah, that is accurate. That's it was incorrect of me. The process and methodology for comment analysis was not sent. I'm not sure that was included in the March 24th. I don't know, Kelsey, if you can tell me if it was.
Okay, let's take a moment and read it to ourselves. And Kelsey, actually, can we zoom into this a little bit more? Thank you.
Yes, this section is new. These last 2 paragraphs, the placeholder for the revised recommendations
Right.
and the process and methodology were added.
Okay, so let's all give ourselves a moment of silence to read it. Okay, and this certainly accurately, at least based on my recollection, accurately reflects what happened on March 4th. But if anyone has any proposed modifications to this or questions about it, please speak up. And obviously what goes under revised recommendations are everything we've done earlier today. And so with that, and not hearing from anyone else, Leah, what is your request of the group at this point?
Approve this document.
Okay, and so we would need a motion to do so?
Yes.
Does anyone so move?
This is Judge Wiley. I make the motion.
All right, thank you,
I'll
Judge Wiley.
I'll second it.
All right, thank you.
We see the language that we're approving.
Which part are you asking to see, Stephen?
I believe before the numerical analysis, there was a resolution. Thank you.
And so I'm going to go ahead and read it, that we approve the summary of public comment and outline of the process for comment analysis as provided in attachment A, what we just looked at, for inclusion in our final report to the Board of Trustees. The folks who moved and seconded, you're fine with this?
Yes.
And Judge Wiley, you're fine with this as well?
Yes.
All right, thank you. Okay, with that, you can go ahead and take a vote.
Bashan? Bree Nelson,
Yes.
Belmont, Fleischman,
No.
Hamilton, Judge Harper, Hardston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
No.
Sarosh,
Yes.
Spyro,
Abstain.
Torres and Breeze, Judge Wiley,
Yes.
Judge Yu. 8 ayes, 2 nays, the motion carries.
Okay, thank you very much, Louisa. Thanks to everyone. Leah, did you have something else on your to-do list for today?
No.
I'm finding this slightly shocking at 3:19, but okay, if you say so.
I'm sorry, we also need to approve the minutes from the last meeting.
Okay, let's do that and then we'll turn to Stephen. Anyone, would anyone like to move?
I move approval of the minutes.
Thank you, Kimberly. Is there a second?
I second. This is Fariba.
Thank you, Fariba.
Sean, Bree Nelson,
Yes.
Helmut, Fleischman,
Yes.
Hamilton, Judge Harper, Hardston,
Yes.
Kirchmeier,
Yes.
McRae,
Yes.
Olvera,
Yes.
Robinson,
Yes.
Judge Rubin, Shining,
Yes.
Sarosh,
Yes.
Spyro,
Yes.
Torres and Breeze, Judge Wiley,
Yes.
Judge Yu. 11 ayes, 0 no, the motion carries.
And thank you, Louisa, for reminding us. I could see blowing past this meeting and not doing that, so thank you. Stephen.
Yeah, I wanted to know how we're going to go about with the final report and amending dissents as necessary.
I'm sorry, amending what?
Dissents. For example, I dissented on 5.4, that became moot. I'd like to revise my dissent to indicate that became moot.
Okay. Leah, are you?
I'd like to, but I mean, just so you know where I'm coming, I'd also like to comment on the public comment process and things we talked about today.
Sure.
Okay.
Short, I mean, briefly, but.
No, I get it. Leah?
Yeah, so I hadn't thought about anyone wanting to amend their prior dissents. So I guess I'll just announce here, if you want to amend your prior dissent, feel free to do so. We'll send out something with a time frame, a timeline, and when we need to get that by. In terms of this final report, we will turn that around as quickly as possible. As you could see from today, it's not intended to be a lengthy document, just what you've just approved, plus the resolutions from earlier today. So we'll turn that around quickly, and then you can draft any amending remarks, additional dissenting opinions that we will add to the report. So just give us to the end of the week to come up with a timeline, and we'll get something out to all of you.
Does that answer the question?
Yeah, mostly. I suppose the issue is when we get the final report, are we going to have another meeting to discuss? And I see you shaking your head.
No, that has not been the intent. We have, my understanding is we have voted on everything. You have, I haven't voted on anything. You all have voted on everything that was outstanding. And there will now be, thank you for raising the issue, a further opportunity to file your individual comments to have it added there too. Julia, you just raised your hand.
Yes. So are all of the dissenting votes attached to the report so we can review them if we choose to?
All of the votes in the last report that went to the board, all of the vote tallies were included. The vote tallies for this amended set of recommendations would be included. Do you mean the prior dissenting opinions that were submitted?
Yeah, because I can't even remember if I asked at any time to have one submitted along
All
with
right.
my
Oh,
vote.
I will recirculate those when we recirculate the timeline.
Thank
When
you.
we circulate the timeline.
That's a good idea. Yeah, we'll make sure to send those back around. Stephen?
I'm sorry, I'm done.
No, that's
But
okay.
by the way, for the record, I'm not complaining about not having another meeting. I just.
Okay, and now my feelings are hurt, but okay.
No. You know what I mean. We have all put in, we have all gone above and beyond.
Yes. Any other questions? I'm not going to say for me since I know nothing. For Leah? No. Okay. Well, at this point, at 3:24, I'm not going to keep you a whole lot longer other than to say that, I don't even know who had the harebrained idea to ask me to chair this, but someone did. So whoever had that idea, I thank them for the opportunity. This has been an incredibly interesting, difficult in a good way, and complicated process. And as I have told many people, this is an extraordinary group of members of the working group, all of whom are so dedicated and informed and well-intentioned and thoughtful and willing to give extraordinary amounts of their time to this very important issue. The issue that we're dealing and grappling with here, the lack of representation for people who really need it, could not be a more significant issue for our courts. And so I thank you as a member of the public for spending all this time on this. And I look forward to working with Leah to put forward and explain some of this, what we've done so far and what the recommendations are to the State Bar Board. Anyone else who wants to attend obviously is welcome to do so. And I think that's it. And I cannot thank Leah. And come on, like the amount of work that Greg, Brady, and others have done, definitely a round of applause for that. And I don't know if Linda's still online using up her, retirement time to be with us, but if she is, another round of applause.
And thank you, Greg.
Yes, incredibly so.
Greg and Brady, yes.
Yeah, absolutely. And I really do hope, Carolyn and I were chatting earlier, I really do hope to be able to actually all see each other in person. It was delightful to see a small number of people today at the State Bar office. And it somehow just seems wrong that we've done all this work and not been in the same place. So anyway, more on that hopefully. And that's it, unless Leah, you wish to add anything?
No, just to thank you. I think you've done an incredible job. I don't think we would have gotten here without such an effective chair. So thank you.
All right. Well, thanks very much to everybody. We're going to end early for once, for all the times that we ended late, and we will go ahead and recirculate everyone's dissenting or commentary from before, get out a deadline for modifying or putting in. I don't even know whether it's modifying or whether you want to add in new comments, but we'll sort that out and we'll get it done. All right. Thanks very much. And look forward to seeing all of you.
Thank you.
Bye.
Bye.